The time we should consult our history. Look at what we've done in the past and see if we can't use it to help us now. We understand that our founders created the greatest country in the history of the world, the greatest democracy, the freest country, a country that has taken more people out of poverty than any country ever. All of us are so fortunate to be Americans. We're not a perfect country. They weren't perfect men and women, and neither are we. But they did it better than anyone else, and that has to be our goal, to keep America a leader. But a great deal of the reason for America's constant ability to self-improve is because we are able to reason. We're able to talk, we're able to discuss, we're able to analyze, we're able to apply our God-given common sense. So let's begin. Continue with the trial. We're going to concentrate on what would be the first two pieces of evidence, the first two witnesses in the trial. Now remember, what we're contrasting this is with the phony impeachment that the House of Representatives, the Democrats, purely brought against the president for non-impeachable offenses. That would be as if I tried to try someone for non-crimes. That's why it's entirely unconstitutional, completely illicit, and in my humble opinion, should be paid for by the Democratic National Committee because it's a political ad. The whole premise, I guess, of that phony political exercise is this theory that President Trump and I were trying to dig up dirt on poor Joe Biden.
Yeah, poor
and nothing
Joe Biden
could be further from the truth. And I think the trial will prove that. On November 28th or so of 2018, when I first found out about the Ukrainian collusion, I wasn't thinking about Joe Biden. He was the furthest thing from my mind. I was sitting there in my office thinking about defending my client against the false Democratic charges of Russian collusion, charges that were manufactured, looks to me like somewhat in the White House, and charges that were manufactured certainly by Obama people and Democrats. And when I was told that there was evidence of Ukrainian criminality and corruption that made whatever was going on in Russia look tame, if anything went on in Russia at all, I met with the gentleman who had the information. He gave it to me in a responsible way. And then I did what I was supposed to do as a good lawyer. I investigated the case to prove my client's innocence. And the mistake I made was I found, wow, did I find a scandal. Ooh. By the time this is all revealed, I predict Teapot Dome will be somewhere in the smaller annals of scandals. This is a scandal at the highest levels of both governments. It involves way beyond Joe Biden. We're going to concentrate on Joe Biden because I want to prove to you that what we were doing here was totally legitimate and required. It was a year and a half, 2 years before any election. It was before he announced as president. It was while the president was still being investigated. Actually got it finished before Biden ever announced. And frankly, I never thought Biden would run. Looked to me like he couldn't cross the street without help. But who knows? So today, with just two pieces of evidence,
What?
I'm going to show you a provable case of bribery.
Quit.
That if it doesn't outrage you, then there's something wrong with your sense of honesty. The background. Mykola Zlochevsky was a minister in the government of President Yanukovych. And this, we're now going back to 2008, 09, 10, 11, 12, 13. that period of time. Yanukovych was what we would call a pro-Russian Ukrainian. He was favorable toward Putin and occasionally would make overtures to the West. He had ministers, and they were called Yanukovych's mafia, because the thing they all had in common was they were stealing from the government and laundering it, much of it through Privat Bank. Zlochevsky was no different. He held several ministries, ecology, environment. But what he did during the time he was in office was he awarded his own company licenses for oil and gas, and very lucrative ones. And his company was operated by his partner, a gentleman named Mykola Listen, and his company was housed actually in Cyprus. So in the very act of getting money into the company, he was laundering it out of Ukraine. So during that period of time that he had to steal like that, the estimates are that he stole about $5 billion. Not the most, by the way. Yanukovych in one deal did $7.5 billion, and that was just one deal. Well, all of a sudden, the revolution of dignity happens. It really begins in 2013. 2014, it breaks out. Happens quick, like these revolutions always happen. And Yanukovych mafia is basically thrown out. They all run away. Yanukovych goes to Russia, where Putin takes care of him. Zlochevsky goes to, I think it's Switzerland. But remember, don't feel sorry for them. They go where their $5 billion is stashed, or their $7 billion, or maybe the poor one's $2 billion. So the Yanukovych mafia goes around the world. However, all of a sudden, a new government's coming in, and the new government's real angry at the old government, and the new government finds out they have $800,000 in the bank, I've been told. Can you imagine that? I think that's true. I haven't been able to completely verify that. I will try. But they sure as heck have almost no money, because these guys were taking out $7 billion and $10 billion and $5 billion. Zlochevsky, 5. So Zlochevsky's now really afraid. He's sitting there. He's basically in exile. He's got his business. He's got his $5 billion, but now noises are getting made that they're going to come after his business, and they're going to come after his money, and they're going to bring a lawsuit against him in London, and they're going to come after him here and there and there and there. And he's going to be down to being maybe just a millionaire. And then President Obama does Zlochevsky the favor of his life. He names Joe Biden the point man for Ukraine. What that means is Joe's going to be in charge of handing out the billions and billions and billions of dollars to rebuild the country. And he's going to try to make the country less corrupt, which of course turns out to be a hilarious joke because he makes it more corrupt. But we don't know that at this point. Zlochevsky hears about Joe Biden. Zlochevsky's a smart man, and he says, I got to have somebody who's more powerful than Poroshenko to protect me in case they want to come after my company and my money, and my savior is Joe Biden. So, in ways that we will show you, through intermediaries, he makes a deal with Joe. This is the first bribe. The deal is, you protect my company, I get you a lot of money. We know one way clearly, and that is hiring Joe's son, who is obviously not qualified for the job, to be on the board, and paying him between $5 and $8 million. There's other forms of money sent to him that we will develop over the course of this trial, which I think you'll find even, well, probably not more shocking, but just as shocking. So basically, what this bribe starts out as is, this is for Zlochevsky to protect his business against being taken by the government of Ukraine. Now, why did they pick Joe? You're going to find out a lot of reasons why, but I don't think you and I really knew Joe Biden. Like going back to his Delaware days, and his family's been monetizing Joe's public office for years. His brother James, his younger brother Hunter. I mean, this little scheme, they sell Joe's office and they make thousands, and then Joe says, I don't know. This little scheme was going on for a long, long time. It became worldwide when he became vice president, and he got the job of point man Because everywhere Joe was a point man, the Biden family enterprise took in now millions. And we'll go through all those too, but let's just stick with this one. But no reason why Zlochevsky, a man of the world, wouldn't know what we didn't know, that the Biden family was in it for money and for big money. So we heard the tape last week. We heard Joe say on tape, you're going to get rid of the prosecutor, and if you don't get rid of the prosecutor, you're not going to get your loan guarantee that you desperately need. As I pointed out to you then, that alone is the crime of bribery. We don't need any more. That's it. It has to be corrupt. Got to add a little evidence that he knew about his son being under investigation. You'll see there's a pile of it. So you could kind of do this on one tape and lots of documents. 3 elements to the crime of bribery, once again. Offering something of value to affect public office, doing it corruptly. Something of value, a loan guarantee, affecting public office, firing the prosecutor, corruptly getting the son, and remember the first bribe, and Zlochevsky, and Zlochevsky's company, and Soros's company, and out of trouble. So there's plenty of corrupt ways. But now we also have witnesses. And the first witness, if I were doing this at a trial, would be a man named Victor Shokin. On January 23rd, 2019, I interviewed Mr. Shokin by Skype. And you're about to see his testimony, and he said pretty much the same things, both in the testimony he gave me during that Skype, that he was fired because Joe Biden didn't want him investigating Burisma and Hunter Biden and Zlochevsky, and that he held back the money unless Poroshenko did it. He'll give you a whole history of how he was harassed before that. I'm going to tell you something else that's very surprising. And we'll hear it from him. So let's take a short break. And then when we come back, you'll be listening to my questioning of Victor Shokin, which took place a few months ago live in Kiev. Of course, it's on tape now, but live then. For those of you who know me, in addition to law and politics, I'm passionate about the Yankees, baseball, football, all sports to watch, golf to play, history to read, opera, classical music to listen to and watch, and cigars to relax and socialize. And I have very definite opinions on the best cigars for the right time and the right place. But the revolution in cigars took place in the 1990s. Most cigars then were machine-made with foreign ingredients. Now it's just the opposite. Most are hecho a mano, man-made, and all organic, natural, and premium. This revolution was led by one man, and one man alone, and his magazine, Marvin Shanken and his Cigar Aficionado magazine. Marvin had been rating wines quite successfully for Wine Spectator magazine, and he brought the rating system, Wine Spectator, to Cigar Aficionado. The first cigars rated in the 90s were soon gone, quick. Even now, the first thing I do when I get my Cigar Aficionado edition is I immediately go look at the ratings. I go look for 92, 93, 94, and I go try them. This quality comparison system revolutionized the cigar industry, and quality rose to the top. Then there's the Cigar of the Year edition. 25 selected, only one number 1. The top ones are going to be hard to get. So subscribe to Cigar Aficionado right now through the link on our website. And then go get the ones that are left or order them and smoke them. And see if you agree with the ratings and let me know. Sometimes I do agree. And when I don't, I let my opinion be known to Marvin. He listens very, very intently. And then he says to me, Rudy, stick to the law. Also, along with rated cigars, Cigar Aficionado has articles on politics, sports, interesting profiles, and Marvin also has Wine Spectator, which I mentioned, and a Whiskey Advocate. So if you like wine, bourbon, scotch, vodka, etc., it's a great guide to the best quality. Subscribe now to Cigar Aficionado through the link on our website. You're going to really enjoy it. It's a great read. Thank you. Oh, you're back. I won't tell you the cigar of the year. Gotta go get it. So now, it's time for us to hear from our first witness, Victor Shokin, who will give us what I would call the background and the beginning of all this in his own words. And this will be corroborated by lots of other people, but this is the first witness and a very important one, the former Prosecutor General of Ukraine, Victor Shokin. So this is a few questions to Mr. Shokin. He spent 2 days with us, so I know he's quite tired, and I know he's been very, very generous with his time. So I'm going to do this quickly as a summary of what you testified to.
Несколько вопросов. Мы знаем, вы уже утомились. Вы 2 дня провели с нами, поэтому я постараюсь очень коротко суммировать все, о чем мы говорили.
First of all, Mr. Shokin, you were the Prosecutor General of Ukraine from what date to what date? What were your...
Прежде всего, в какие даты вы были генеральным прокурором в Украине?
С 10 февраля 2015 года
From February 15th, 2015
по 3 апреля 2016 года.
Till April the 3rd, 2016.
And when you came into that office, there was already a case against Burisma. Is that correct?
Когда вы вступили в должность, дело Бурисма уже было в рассмотрении.
Да.
Yes.
And the case involved money laundering, abuse of power, there was 5 or 6 cases. Isn't that correct? It was not just one case. It was a number of cases.
Правда ли то, что там была на самом деле целая группа дел, которые можно категоризовать по некоторым направлениям?
Ну, дело в том, что там действительно было очень много дел, но эти дела представляли единое целое. Они касались буризмы, разных направлений незаконной деятельности, но одной организации буризма.
Actually, yes, there were quite a few particular separate investigative cases, but they were all concerning one company. That's why they were combined into one investigation.
And just to simplify it, the basic problem with Burisma is that Mr. Zlochevsky, who owned it, had been a minister of the government.
Мы правильно понимаем, что основная проблема была в том, что господин Злочевский, который является владельцем, одновременно был министром в правительстве Украины.
Да, действительно, он был министром, и действительно, используя свое служебное положение, он получил или незаконно взял себе, по-моему, 7 или 9 разрешений на добычу газа.
Absolutely yes. While being a minister in the cabinet of ministers, he illegally issued to himself 9 licenses for mineral resources, exploration.
Did he say illegally?
Незаконно.
Незаконно, я сказал, незаконно.
9 лицензий.
Я точно не помню, 7 или 9.
About 9. These are licenses so that the company has a right to explore the mineral resources in the country.
And there came a time when Mr. Zlochevsky left the country. Isn't that correct?
И примерно в это же время господин Злочевский покинул страну.
Ну, страну он покинул раньше, еще покинул страну в 2014 году.
No, he left Ukraine much earlier in 2014.
And when he left, was he under suspicion for having taken a lot of money out of the company?
Когда он покинул страну, был ли он под подозрением о том, что он украл много денег?
Да, ему вменялось незаконное обогащение, отмытие денег, добытых преступным путем.
Yeah, he was incriminated with unlawful enrichment, money laundering.
And then there came a time in which he made appointments to his board, particularly Devin Archer and Hunter Biden.
И в какой момент произошло назначение новых представителей в совет директоров, особенно Хантера Байдена и Дэвида Арчера?
Насколько я помню, это было в апреле 2014 года.
as far as I could recall, that was in April 2014.
When was his father, Vice President Joseph Biden, appointed or named by President Obama the point man for Ukraine?
Вы помните, когда отец Хантера Байдена, Джо Байден, был назначен Обамой представителем по Украине?
Точно я не помню, но насколько мне память, если не изменяет, это было либо в конце 13-го, либо в начале 14-го года.
I can't tell you for sure, but as far as I remember, that was end of 2013, beginning of 2014.
Before Hunter Biden was appointed to the board.
Перед тем, как Хантер Байден был назначен секретарем. Definitely yes.
So as you can see, Hunter Biden and Devin Archer were not appointed to the board until after Joe Biden was named the point man for Ukraine. And just took a break here because I want to emphasize the following point, which is going to be emphasized now when we go back to the video, which will show the great and vast power that Joe Biden had over the country of Ukraine. So let's go back to the video.
Has it occurred to you that there's a certain irony here that the president is accused of and has acknowledged wanting to get information about your son Hunter and his dealings with Ukraine, and this process of impeachment has ensured that everyone knows about Hunter's dealings with Ukraine?
That's a good thing, and no one's found anything wrong with his dealings with Ukraine except they say it sets a bad image.
Well, do you agree that it sets a bad image?
And my son said that.
Do you think it was wrong for him to take that position?
No.
Knowing that it was really because that company wanted access to you.
Well, that's not true. You're saying things you do not know what you're talking about. No one said that. Who said that?
Well, don't
Who
you
said
think
that?
don't you think that it's just one of those things where people think, well, that seems kind of sleazy. Why would he have that job if not for who his father was?
Because he's a very bright guy.
I guess the question I'm kind of asking is,
Appearance.
was it right?
His appearance.
Yeah.
Yeah. Well, he said he regretted having done it.
Yeah.
Speaks for himself. It's a grown man.
You're going to predict a win tomorrow night? Impeachment has ensured that everyone knows about Hunter's dealings with Ukraine.
That's a good thing, and no one's found anything wrong with his dealings with Ukraine except they say it sets a bad image.
Well, do you agree that it sets a bad image?
And my son said that.
Do you think it was wrong for him to take that position,
No.
knowing that it was really because that company wanted access to you?
Well, that's not true. You're saying things you do not know what you're talking about. No one.
Just a vote on whether you like the president or not, whether you agree with the president or not, whether your politics are the same. This is a vote over whether the constitutional standard is met. And the Constitution says for impeachment that the only grounds for impeachment are treason, bribery, or other high crimes and misdemeanors. And what Professor Dershowitz walked through very effectively, and actually before him, what Ken Starr walked through very effectively, is that the constitutional threshold requires a grave, serious crime of the level of treason or bribery. House managers didn't even try to allege a crime, and they certainly didn't prove one, and that's why, as a matter of law, and by the way, we did this whole digression on quid pro quo and all the discussion about additional witnesses for whether there was a quid pro quo, whether there wasn't a quid pro quo. As a matter of law, it didn't matter. It was a side diversion. That was one of the things we clarified during the questioning period that I think was really critical to getting the 4 votes to end, to not have additional witnesses, is that we asked, actually Lindsey Graham and I together wrote the question asking, even if you assume for sake of argument that there was a quid pro quo, does that change the legal analysis? Is this a high crime or misdemeanor? And the president's lawyers answered exactly right, that even if there were a quid pro quo, you got disputed testimony on that, it doesn't matter, because the president has the authority to investigate corruption, and there was more than sufficient evidence of potential corruption with Burisma and the Bidens for the president to ask for an investigation on it.
Donald Trump couldn't find Ukraine on a map if you had the letter U and a picture of an actual physical crane next to it. He knows that this is, an administration defined by ignorance of the world.
You can put half of Trump's supporters into what I call the basket of deplorable's.
And so that's partly him playing to their base.
Anyone who supported this president is, at best, looking the other way on racism, at best.
credulous boomer rube demo that backs Donald Trump, that wants to think that Donald Trump's the smart one, and they're y'all elitists are them.
Trump always loves the low information guy. You elitists with your geography and your maps. Issue of racism across the country, because that's his base.
Your math and your reading.
Yeah, you're reading, you know, your geography.
Attempt by the House to attempt an accommodations process, even though the White House offered to engage in an accommodations process. There was no attempt by the House to use other mechanisms to resolve the differences with the executive branch. It was just straight to impeachment. Now, they've asserted today and on other occasions that the President's counsel, that I and my colleagues have made bad faith legal arguments that are just window dressing. Now, in an ordinary court of law, one doesn't accuse opposing counsel of making bad faith arguments lightly. And if you make that accusation, it has to be backed up with analysis. But there hasn't been analysis here. There's just been accusation. When the President asserts the immunity of his senior advisors, that's a principle that's been asserted by virtually every president since Nixon. And let me read you what Attorney General Janet Reno during the Clinton administration said about this exact immunity. She said that immediate advisors to the President are immune from being compelled to testify before Congress, and that, quote, the immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests, end quote. And she went on to say, quote, compelling one of the President's immediate advisors to testify on a matter of executive decision-making would raise serious constitutional problems no matter what the assertion of congressional need, end quote. Was that bad faith? Was Attorney General Reno asserting that principle in bad faith? And President Clinton? President Obama asserted the same principle for his senior political advisor. Was that bad faith? Of course not. These are principles defending the separation of powers that presidents have asserted for decades. President Trump was defending the institutional interests of the office of the presidency and asserting the same principles here. That is vital for the continued operation of the separation of powers. Now, House managers have also said that once the president asserted these defects in their subpoenas and resisted them, they had no time to do anything else. They had to just go straight to impeachment. They couldn't accommodate, they couldn't go through a contempt process, they couldn't litigate. But the idea that there is no time for dealing with that friction with the executive branch is really antithetical to the proper functioning of the separation of powers. It goes against part of the way the separation of powers is supposed to work. That interbranch friction is meant to take time to resolve. It's meant to slow things down and to be somewhat difficult to work through and to force the branches to work together to accommodate the interests of each branch, not just to jump to the conclusion that, well, we have no time for that. We have to assert absolute authority on one side of the equation. And this is something that Justice Brandeis pointed out in a famous dissent in Myers versus the United States, but has since been cited many times by the court majority. He said, quote, the doctrine of the separation of powers was adopted by the Convention of 1787, not to promote efficiency. So he's saying not to make government move quickly, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among the departments to save the people from autocracy. That is a vitally important principle, that the friction between the branches, even if it means taking longer, even if it means not jumping straight to impeachment, is part of the constitutional design. And it's required to force the branches to determine incrementally where their interests lie, so to resolve disputes incrementally, and not to jump straight to the ultimate nuclear weapon of the Constitution. We've also heard from the House managers that everything the president did here, asserting prerogatives of his office asserting principles of immunity must be wrong, must be rejected, because only the guilty will assert a privilege. Only the guilty won't allow evidence. That is definitely not a principle of American jurisprudence. It's antithetical to fundamental principles of our system of laws. As we pointed out in our trial memorandum in Border-Kircher versus Hayes and in other decisions, the Supreme Court has made clear that the very idea of punishing someone for asserting rights or privileges, or suggesting that asserting the right or privilege is evidence of guilt, is contrary to basic principles of due process. And it takes on an even more malignant tenor to it when that principle is asserted in the context of a dispute between the branches relating to the boundaries of their relative powers. Because what the House is essentially asserting in this case is that any assertion of the prerogatives of the office of the president, any attempt to maintain the principles of separation of powers, of executive confidentiality that have been asserted by past presidents, can be treated by the House as evidence of guilt. And here their entire second article of impeachment is structured on the assumption that the House can treat the assertion of principles grounded in the separation of powers as an impeachable offense. I mean, boiled down to its essence, it is an assertion that defending the separation of powers, if the president does it in a way that they don't like, in a time that they don't like, can be treated as an impeachable offense. And that's an incredibly dangerous assertion. Because if it were accepted, it would fundamentally alter the balance between the different branches of our government. It would suggest, and Professor Turley explained this, Professor Dershowitz explained it here, that if Congress makes a demand on the executive and the executive resists, based on separation of powers principles that past presidents have asserted, Congress can nonetheless say, we've decided to proceed by impeachment. We have the sole power, and this is the principle they assert in the House Judiciary Committee report. We have the sole power of impeachment. That means we are the sole judge of our own actions. There's no need for accommodation. There's no need for the courts. We will determine that any resistance you provide is itself impeachable. That would fundamentally transform our government by essentially giving the House the same sort of power as a parliamentary system to use impeachment as, in effect, a vote of no confidence against a prime minister, not the way the framers set up our three-branch system of government with a powerful executive who would be independent from the legislature. That's why Professor Turley explained that the second article of impeachment here would be an abuse of power by Congress. It would make the executive dependent on Congress in a manner antithetical to the system that the framers envisioned. So why is it that there are all of these defects in the House manager's case for impeachment? Why are they asserting principles like only the guilty would assert privileges? That's not part of our system of law. Why are they asserting that if the executive resists, the House has the sole power to determine the boundaries of its own power in relation to the executive? Also not something that is in our system of jurisprudence. I think it's because, and why the lack of due process in the proceedings below? I think, as we've explained, it's because this was a purely partisan impeachment from the start. It was purely partisan and purely political. And that's something that the framers foresaw. And I'll point to one passage from Federalist number 65. A number of different passages from that have been cited over the course of the past week, but I don't think this one has. It's just after Hamilton points out, he warns that an impeachment in the House could be the result of persecution of an intemperate or designing majority in the House of Representatives. And then he goes on. Though this latter supposition may seem harsh and might not likely often to be verified, yet it ought not to be forgotten that the demon of faction will, at certain seasons, extend his scepter over all numerous bodies of men. Now that's very 18th century language. We don't talk about demons extending their scepter over men, but it's prescient nonetheless. We might not be comfortable with the terms, but it's accurate for what can happen. And that is what's happened in this impeachment. This was a purely partisan political process. It was opposed bipartisanly in the House. It was done by a process that was not designed to persuade anyone or to get to the truth or to provide process and abide by past precedents. It was done to get it finished by Christmas on a political timetable. And it's not something that this chamber should condone. That in itself provides a sufficient and substantial reason for rejecting the articles of impeachment. Members of the Senate, it's been an honor to be able to address you over the past week and a half or 2 weeks, and I thank you for your attention, and I yield to Mr. Secretary.
In 2018 alone, the National Human Trafficking Hotline identified over 23,000 human trafficking victims in the United States. 65% of these victims were women. More than 1 in 5 were children. Human traffickers prey on their most vulnerable citizens and people. They're vicious, they're violent. My administration is fighting these monsters, persecuting and prosecuting them, and locking them away for a very, very long time. We've had a tremendous track record, the best track record in a long time. We are dismantling the criminal organizations that make large-scale human trafficking possible.
Thanks for having me, Sandra. All right, great to have you here this morning. So what ultimately do you believe will happen with this vote on witnesses?
Well, we are coming to a conclusion of this, and I believe the president will be acquitted, and I believe we will not be having witnesses. That vote will be held later today, but people realize, and Senator Alexander is absolutely right, impeachment should never be partisan. What we have here was a very partisan political process rushed through the House, political stunts being played by the House, and if there was any abuse of power, it was by the House with these impeachment articles.
The Democratic leader will state the inquiry.
Is the Chief Justice aware that in the impeachment trial of President Johnson, Chief Justice Chase, as presiding officer, cast tie-breaking votes on both March 31st and April 2nd, 1868?
I am, Mr. Leader. The one concerned a motion to adjourn, the other concerned a motion to close deliberations. I do not regard those isolated episodes 150 years ago as sufficient to support a general authority to break ties. If the members of this body, elected by the people and accountable to them, divide equally on a motion, the normal rule is that the motion fails. I think it would be inappropriate for me, an unelected official from a different branch of government, to assert the power to change that result so that the motion would succeed.
This is the day after the vote regarding witnesses. I'm told that last Thursday, Speaker Pelosi tweeted that if something along the lines of if the Senate didn't hear witnesses or request documents, that the process would not be fair. Let's speak of fairness. Let's speak of fairness both to the American people, the accused, and the process. House managers did a lazy, slipshod job. They didn't go after the documents they needed. They didn't go after the witnesses that they really apparently wanted. They wanted the Senate to do that. Transparently a political maneuver. And so when they come to us and they say, listen, we didn't do our work, but will you do our work for us? That's not fair to the process. It's also not fair to the American people. They want to drag out something before an election precisely for political causes. And it's certainly not fair to the accused. The president may be the president, but in our country, the accused still has fair process. I'm sorry that it came out this way, a divisive thing, but I actually think the process worked. We have asked the House to do their job.
I'm concerned about lowering impeachment standards to fit a paucity of evidence and an abundance of anger. I believe this impeachment not only fails to satisfy the standard of past impeachments, but would create a dangerous precedent for future impeachments.
Submit 17 witnesses. We're talking about now additional witnesses. that the managers are put forward and that Democratic leader Schumer has discussed. He's discussed 4 witnesses in particular, as if this body would, if it were to grant witnesses, would say, yes, you get those 4 witnesses, and the White House and the President's Council gets what? Whatever I want. That's what he said, Mr. Schumer. Whatever I want, here's who I want. I want Adam Schiff. I want Hunter Biden. I want Joe Biden. I want the whistleblower. I want to also understand there may be additional people within the House Intelligence Committee that have had conversations with that whistleblower. There have been 17 witnesses. We're talking about now additional witnesses that the managers are put forward and that Democratic leader Schumer has discussed. He's discussed 4 witnesses in particular, as if this body would, if it were to grant witnesses, would say, yes, you get those 4 witnesses, and the White House and the President's Council gets what? Whatever I want. That's what he said, Mr. Schumer. Whatever I want, here's who I want. I want Adam Schiff. I want Hunter Biden. I want Joe Biden. I want the whistleblower. I want to also understand there may be additional people within the House Intelligence Committee that have had conversations with that whistleblower. There have been 7.
If the whistleblower, as is alleged in some public reports, actually did work for then Vice President Biden on Ukraine issues, exactly what was his role? What was his involvement when issues were raised? We know from testimony that questions were raised about the potential conflict of interest that the vice president then had when his son was sitting on the board of Burisma. Was the alleged whistleblower involved in any of that and in making decisions to not do anything related to that? Did he have some reason to want to put the deep 6 on any question raising any issue about what went on with the Bidens and Burisma and firing Shokin and withholding $1 billion in loan guarantees and enforcing a very explicit quid pro quo? You won't get this $1 billion until you fire him. We don't know.
If Paul went first and allowed him to ask, he asked his question. Name somebody that Rand Paul believes to be the whistleblower, and the Chief Justice has made clear he wants no part of that, will have no part of that, and he's not going to do it. Rand Paul continues to air his grievances. He continues to air them in other ways on social media. I'm not going to help him promote that. He thought it was important to do this in this setting. Even his friend Lindsey Graham said, well, he thinks there are legitimate questions here. This was not the place to do it. Call that a political stunt. Rand Paul would say it's a principled argument. Republicans make a good point. The whistleblower started all this. Why has the whistleblower never been questioned? Shouldn't the House Democrats have found a secure way to do that? It's a legitimate point of debate as we go through this. Is outing the whistleblower in a public setting the way to make your point? I think we could have a conversation about that. This process is broken. There's no trust between the two parties. It is perfectly legitimate that the Democrats' argument is just about everything the whistleblower alleged has been proven through other sources, so we don't need to do this. But you're asking the Congress, the Senate now, to remove the President of the United States. It's a legitimate point for the President's team of the Republicans to say, shouldn't we go to the very origin of this?
I want to say this for Donald Trump, who I may well be voting to impeach.
I think that Donald Trump has already done a number of things which legitimately raise the question of impeachment.
And I will fight every day until he is impeached.
I rise today, Mr. Speaker, to call for the impeachment of the President of the United States of America.
The main reason I'm interested is not so much to win the Senate, which is a byproduct. It's because I think he's committed impeachable offenses and he's the scarlet eye on his chest.
But if we get to that point, then yes, I think that's grounds to start impeachment proceedings.
So we're calling upon the House to begin impeachment hearings immediately.
Why do you think that President Trump specifically should be impeached?
Well, there are 5 reasons why we think he should be impeached.
On the impeachment of Donald Trump, would you vote yes or no?
I would vote yes. I would vote to impeach.
Because we're going to go in there, we're going to impeach the mother.
I introduced articles of impeachment in July of 2017. All I did yesterday was make sure that those articles did not expire.
I'm concerned that if we don't impeach this president, he will get reelected.
It is time to bring impeachment charges against him.
My personal view is that he richly deserves impeachment.
America demanded change.
Donald Trump wins the presidency.
And change is what we got. Under President Trump, America is stronger, safer, and more prosperous than ever before.
Best wage growth I think we've seen in almost a decade. Unemployment rate sinking to a 49-year low.
Unemployment for African Americans, it fell to a new low.
Unemployment for Hispanics hit an all-time record low.
And ladies and gentlemen, the best is yet to come. I'm Donald J. Trump, and I approve this message.
The time. We should consult our history. Look at what we've done in the past and see if we can't use it to help us now. We understand that our founders created the greatest country in the history of the world. The greatest democracy, the freest country, a country that has taken more people out of poverty than any country ever. All of us are so fortunate to be Americans. We're not a perfect country. They weren't perfect men and women, and neither are we. But they did it better than anyone else, and that has to be our goal, to keep America a leader. But a great deal of the reason for America's constant ability to self-improve is because we are able to reason. We're able to talk, we're able to discuss, we're able to analyze, we're able to apply our God-given common sense. So let's begin.
Has it occurred to you that there's a certain irony here that the president is accused of and has acknowledged wanting to get information about your son Hunter and his dealings with Ukraine, and this process of impeachment has ensured that everyone knows about Hunter's dealings with Ukraine?
That's a good thing, and no one's found anything wrong with his dealings with Ukraine except they say it sets a bad image.
Would you agree that it sets a bad image?
And my son said that.
Do you think it was wrong for him to take that position?
No.
Knowing that it was really because that company wanted access to you.
Well, that's not true. You're saying things you do not know what you're talking about. No one said that. Who said that?
Well, don't you think that it's just one of those things where people think, well, that seems kind of sleazy. Why would he have that job if not for who his father was?
Because he's a very bright guy.
I guess the question I'm kind of asking is, was it right?
His appearance.
Yeah.
Yeah. Well, he said he regretted having done it. Speaks for himself. It's a grown man.
You're going to predict a win tomorrow night? Impeachment has ensured that everyone knows about Hunter's dealings with Ukraine.
That's a good thing, and no one's found anything wrong with his dealings with Ukraine except they say it sets a bad image.
Well, do you agree that it sets a bad image?
And my son said that.
Do you think it was wrong for him to take that position?
No.
Knowing that it was really because that company wanted access to you?
Well, that's not true. You're saying things you do not know what you're talking about. No one...
Just a vote on whether you like the president or not, whether you agree with the president or not, whether your politics are the same. This is a vote over whether the constitutional standard is met. And the Constitution says for impeachment that the only grounds for impeachment are treason, bribery, or other high crimes and misdemeanors. And what Professor Dershowitz walked through very effectively, and actually before him, what Ken Starr walked through very effectively, is that the constitutional threshold requires a grave, serious crime of the level of treason or bribery. House managers didn't even try to allege a crime, and they certainly didn't prove one, and that's why, as a matter of law, and by the way, we did this whole digression on quid pro quo and all the discussion about additional witnesses for whether there was a quid pro quo, whether there wasn't a quid pro quo. As a matter of law, it didn't matter. It was a side diversion. That was one of the things we clarified during the questioning period that I think was really critical to getting the 4 votes to not have additional witnesses, is that we asked, actually Lindsey Graham and I together wrote the question asking, even if you assume for sake of argument that there was a quid pro quo, does that change the legal analysis? Is this a high crime or misdemeanor? And the president's lawyers answered exactly right, that even if there were a quid pro quo, you got disputed testimony on that, it doesn't matter, because the president has the authority to investigate corruption, and there was more than sufficient evidence of potential corruption with Burisma and the Bidens for the president to ask for an investigation on it.
Donald Trump couldn't find Ukraine on a map if you had the letter U and a picture of an actual physical crane next to it. He knows that this is, an administration defined by ignorance of the world.
You can put half of Trump's supporters into what I call the basket of deplorables.
And so that's partly him playing to their base.
Anyone who supported this president is, at best, looking the other way on racism, at best.
The credulous boomer Rube demo that backs Donald Trump, that wants to think that Donald Trump's a smart one, and y'all elitists are them.
Trump always loves the low information guy. You elitists with your geography and your maps.
Racism across the country, because that's his base.
Your math and your reading.
Yeah, you're reading, your geography.
Attempt an accommodations process, even though the White House offered to engage in an accommodations process. There was no attempt by the House to use other mechanisms to resolve the differences with the executive branch. It was just straight to impeachment. Now, they've asserted today and on other occasions that the President's counsel, that I and my colleagues have made bad faith legal arguments that are just window dressing. Now, in an ordinary court of law, one doesn't accuse opposing counsel of making bad faith arguments lightly. And if you make that accusation, it has to be backed up with analysis. But there hasn't been analysis here. There's just been accusation. When the president asserts the immunity of his senior advisors, That's a principle that's been asserted by virtually every president since Nixon. And let me read you what Attorney General Janet Reno during the Clinton administration said about this exact immunity. She said that immediate advisors to the president are immune from being compelled to testify before Congress, and that, quote, the immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests, end quote. And she went on to say, quote, compelling one of the president's immediate advisors to testify on a matter of executive decision-making would raise serious constitutional problems no matter what the assertion of congressional need, end quote. Was that bad faith? Was Attorney General Reno asserting that principle in bad faith? And President Clinton? President Obama asserted the same principle for his senior political advisor. Was that bad faith? Of course not. These are principles defending the separation of powers that presidents have asserted for decades. President Trump was defending the institutional interests of the office of the presidency and asserting the same principles here. That is vital for the continued operation of the separation of powers. Now, House managers have also said that once the president asserted these defects in their subpoenas and resisted them, they had no time to do anything else. They had to just go straight to impeachment. They couldn't accommodate, they couldn't go through a contempt process, they couldn't litigate. But the idea that there is no time for dealing with that friction with the executive branch is really antithetical to the proper functioning of the separation of powers. It goes against part of the way the separation of powers is supposed to work. That interbranch friction is meant to take time to resolve. It's meant to slow things down and to be somewhat difficult to work through and to force the branches to work together to accommodate the interests of each branch, not just to jump to the conclusion that, well, we have no time for that. We have to assert absolute authority on one side of the equation. And this is something that Justice Brandeis pointed out in a famous dissent in Myers versus the United States, but has since been cited many times by the court majority. He said, quote, the doctrine of the separation of powers was adopted by the Convention of 1787 not to promote efficiency. So he's saying not to make government move quickly, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among the departments, to save the people from autocracy. That is a vitally important principle, that the friction between the branches, even if it means taking longer, even if it means not jumping straight to impeachment, is part of the constitutional design. And it's required to force the branches to determine incrementally where their interests lie, so to resolve disputes incrementally, and not to jump straight to the ultimate nuclear weapon of the Constitution. We've also heard from the House managers that everything the president did here, asserting prerogatives of his office, asserting principles of immunity, must be wrong, must be rejected, because only the guilty will assert a privilege. Only the guilty won't allow evidence. That is definitely not a principle of American jurisprudence. It's antithetical to fundamental principles of our system of laws. As we pointed out in our trial memorandum in Border-Kircher versus Hayes and in other decisions, the Supreme Court has made clear that the very idea of punishing someone for asserting rights or privileges, or suggesting that asserting the right or privilege is evidence of guilt, is contrary to basic principles of due process. And it takes on an even more malignant tenor to it when that principle is asserted in the context of a dispute between the branches relating to the boundaries of their relative powers. Because what the House is essentially asserting in this case is that any assertion of the prerogatives of the office of the president, any attempt to maintain the principles of separation of powers of executive confidentiality that have been asserted by past presidents, can be treated by the House as evidence of guilt. And here, their entire second article of impeachment is structured on the assumption that the House can treat the assertion of principles grounded in the separation of powers as an impeachable offense. I mean, boiled down to its essence, it is an assertion that defending the separation of powers, if the president does it in a way that they don't like, in a time that they don't like, can be treated as an impeachable offense. And that's an incredibly dangerous assertion. Because if it were accepted, it would fundamentally alter the balance between the different branches of our government. It would suggest, and Professor Turley explained this, Professor Dershowitz explained it here, that if Congress makes a demand on the executive and the executive resists, based on separation of powers principles that past presidents have asserted, Congress can nonetheless say, we've decided to proceed by impeachment. We have the sole power, and this is the principle they assert in the House Judiciary Committee report. We have the sole power of impeachment. That means we are the sole judge of our own actions. There's no need for accommodation. There's no need for the courts. We will determine that any resistance you provide is itself impeachable. That would fundamentally transform our government by essentially giving the House the same sort of power as a parliamentary system to use impeachment as in effect a vote of no confidence against a prime minister, not the way the framers set up our three-branch system of government with a powerful executive who would be independent from the legislature. That's why Professor Turley explained that the second article of impeachment here would be an abuse of power by Congress. It would make the executive dependent on Congress in a manner antithetical to the system that the framers envisioned. So why is it that there are all of these defects in the House manager's case for impeachment? Why are they asserting principles like only the guilty would assert privileges? That's not part of our system of law. Why are they asserting that if the executive resists, the House has the sole power to determine the boundaries of its own power in relation to the executive? Also not something that is in our system of jurisprudence. I think it's because, and why the lack of due process in the proceedings below? I think, as we've explained, it's because this was a purely partisan impeachment from the start. It was purely partisan and purely political. And that's something that the framers foresaw. And I'll point to one passage from Federalist number 65. A number of different passages from that have been cited over the course of the past week. But I don't think this one has. It's just after Hamilton points out, he warns that an impeachment in the House could be the result of persecution of an intemperate or designing majority in the House of Representatives. And then he goes on. Though this latter supposition may seem harsh and might not likely often to be verified, yet it ought not to be forgotten that the demon of faction will, at certain seasons, extend his scepter over all numerous bodies of men. Now that's very 18th century language. We don't talk about demons extending their scepter over men, but it's prescient nonetheless. We might not be comfortable with the terms, but it's accurate for what can happen. And that is what's happened in this impeachment. This was a purely partisan political process. It was opposed bipartisanly in the House. It was done by a process that was not designed to persuade anyone or to get to the truth or to provide process and abide by past precedents. It was done to get it finished by Christmas on a political timetable. And it's not something that this chamber should condone. That in itself provides a sufficient and substantial reason for rejecting the articles of impeachment. Members of the Senate, it's been an honor to be able to address you over the past week and a half or 2 weeks, and I thank you for your attention, and I yield to Mr. Secretary.
lawyers, fellow lawyers, it's a great honor for me to stand
Alan Dershowitz
before you today to present a constitutional argument against the impeachment and removal not only of this president, but of all and any future presidents who may be charged with the unconstitutional grounds of abuse of power and obstruction of Congress. I stand before you today as I stood in 1973 and 1974 for the protection of the constitutional and procedural rights of Richard Nixon, who I personally abhorred, and whose impeachment I personally favored. And as I stood for the rights of Bill Clinton, who I admired, and whose impeachment I strongly opposed. I stand against the application and misapplication of the constitutional criteria in every case and against any president without regard to whether I support his or her parties or policies. I would be making the very same constitutional argument had Hillary Clinton, for whom I voted, been elected and had a Republican House voted to impeach her on these unconstitutional grounds. I am here today because I love my country and our Constitution. Everyone in this room shares that love. I will argue that our Constitution and its terms, high crimes and misdemeanors, do not encompass the two articles charging abuse of power and obstruction of Congress. In offering these arguments, I stand in the footsteps and in the spirit of Justice Benjamin Curtis, who was of counsel to impeach President Andrew Johnson, and who explained to the Senate that, quote, a greater principle was at stake than the fate of any particular president. And of William Evarts, a former Secretary of State, another one of Andrew Johnson's lawyers, who reportedly said that he had come to the defense table not as a partisan, not as a sympathizer, but to defend the Constitution. The Constitution, of course, provides that the Senate has the sole role and power to try all impeachments. In exercising that power, the Senate must consider three issues in this case. The first is whether the evidence presented by the House managers establishes, by the appropriate standard of proof beyond a reasonable doubt, that the factual allegations occurred. The second is whether, if these factual allegations occurred, did they rise to the level of abuse of power and or obstruction of Congress. Finally, the Senate must determine whether abuse of power and obstruction of Congress are constitutionally authorized criteria for impeachment. The first issue is largely factual, and I leave that to others. The second is a combination of traditional and constitutional law, and I will touch on those. The third is a matter of pure constitutional law. Do charges of abuse and obstruction rise to the level of impeachable offenses under the Constitution? I will begin, as all constitutional analysis begins, with the text of the Constitution governing impeachment. I will then examine why the framers selected the words they did as the sole criteria authorizing impeachment. In making my presentation, I will transport you back to a hot summer in Philadelphia and a cold winter in Washington. I will introduce you to patriots and ideas that helped shape our great nation. To prepare for this journey, I have immersed myself in a lot of dusty old volumes from the 18th and 19th century. I ask your indulgence as I quote from the wisdom of our founders. This return to the days of yesteryear is necessary because the issue today is not what the criteria of impeachment should be, not what a legislative body or a constitutional body might today decide are the proper criteria for impeachment of a president, but what the framers of our Constitution actually chose and what they expressly and implicitly rejected. I will ask whether the framers would have accepted such vague and open-ended terms as abuse of power and obstruction of Congress as governing criteria. I will show by a close review of the history that they did not and would not accept such criteria for fear that these criteria would turn our new republic into a British-style parliamentary democracy in which the chief executive's tenure would be, in the words of James Madison, the father of our Constitution, at the pleasure of the legislature. The conclusion I will offer for your consideration is similar, though not identical, to that advocated by highly respected Justice Benjamin Curtis, who, as you know, dissented from the Supreme Court's notorious decision in Dred Scott, and who, after resigning in protest from the High Court, served as counsel to President Andrew Johnson in the Senate impeachment trial. He argued, and I quote, "There can be no crime, there can be no misdemeanor without a law, written or unwritten, express or implied." In so arguing, he was echoing the conclusion reached by Dean Theodore Dwight of the Columbia Law School, who wrote in 1867, just before the impeachment, "Unless a crime is specifically named in the Constitution, treason and bribery, impeachments like indictments can only be instituted for crimes committed against the statutory law of the United States." As Judge Starr said earlier today, he described that as the weight of authority being on the side of that proposition at a time much closer to the framing than we are today. The main thrust of my argument, however, and the one most relevant to these proceedings, is that even if that position is not accepted, even if criminal conduct were not required, the framers of our Constitution implicitly rejected, and if it had been presented to them, would have explicitly rejected, such vague terms as abuse of power and obstruction of Congress as among the enumerated and defined criteria for impeaching a president. You will recall that among the articles of impeachment against President Johnson were accusations of non-criminal but outrageous misbehavior, including ones akin to the abuse of power and obstruction of Congress. For example, Article 10 charged Johnson did attempt to bring into disgrace, ridicule, hatred, and contempt and reproach the Congress of the United States. Article 11 charged Johnson with denying that Congress was authorized by the Constitution to exercise the legislative power, and denying that the legislation of said Congress was obligatory upon him. Pretty serious charges. Here's how Justice Curtis responded to these non-criminal charges. Quote, "My first position is that when Congress speaks of treason, bribery, and other crimes and misdemeanors, it refers to and includes only high criminal offenses against the United States, made so by some law of the United States, existing when the acts complained of were done. And I say," he continued, "that this is plainly to be inferred from each and every one of the provisions of the Constitution on the subject of impeachment." And I will briefly review those other provisions of the Constitution with you. Judge Curtis's interpretation is supported. Indeed, in his view, it was compelled by the constitutional text. Treason, bribery, and other crimes and misdemeanors are high crimes. Other high crimes and misdemeanors must be akin to treason and bribery. Curtis cited the Latin phrase nocitur ad soci, I'm sorry for the mispronunciation, referring to a classic rule of interpretation that when the meaning of a word that is part of a group of words is uncertain, you should look to the other words in that group that provide interpretive context. The late Justice Anthony Scalia gave the following current example. If one speaks of Mickey Mantle, Rocky Marciano, Michael Jordan, and other great competitors, the last noun does not reasonably refer to Sam Walton, who was a great competitor, but in business, or to Napoleon, a great competitor on the battlefield. Applying that rule to the groups of words treason, bribery, and other high crimes and misdemeanors, the last 5 words should be interpreted to include only serious criminal behavior akin to treason and bribery. Justice Curtis then reviewed the other provisions of the Constitution that relate to impeachment. First, he started with the provision that says, "The President of the United States shall have the power to grant reprieves and pardons," listen now, "for offenses against the United States, except in cases of impeachment." He cogently argued that if impeachment were not an offense against the United States, was not based on an offense against the United States, there would have been no need for any constitutional exception. He then went on to a second provision. "The trial of all crimes, except in cases of impeachment, shall be by jury." This demonstrated, according to Curtis, that impeachment requires a crime. But unlike other crimes, it does not require a jury trial. You are the judge and the jury. He also pointed out that impeachment trial, by the express words of the Constitution, requires an acquittal or a conviction, judgments generally rendered only in the trial of crimes. Now, President Johnson's lawyers, of course, argued in the alternative, as all lawyers do when there are questions of fact and of law. He argued that Johnson did not violate the articles of impeachment, as you've heard from other lawyers today, but even if he did, that the articles do not charge impeachable offenses, which is the argument that I am making before you this evening. Justice Curtis's first position, however, was that the articles did not charge an impeachable offense because they did not allege high crime offenses against the United States. According to Harvard historian and law professor Nicholas Bowie, Curtis's constitutional arguments were persuasive to at least some senators who were no friends of President Johnson, including the co-authors of the 13th and the 14th Amendments. As Senator William Pitt Fessenden later put it, Judge Curtis gave us the law, and we followed it. Senator James W. Grimes echoed Curtis's argument by refusing to accept an interpretation of high crimes and misdemeanors that changes according to the law of each senator's judgment enacted in his own bosom after the alleged commission of the offense. Though he desperately wanted to see President Johnson, who he despised, out of office, he believed that an impeachment and removal without the violation of law would be, quote, construed into approval of impeachments as part of future political machinery. According to Professor Bowie, Justice Curtis's constitutional arguments may well have contributed to the decision by at least some of the 7 Republican dissidents to defy their party and vote for acquittal, which was secured by a single vote. Now, today, Professor Bowie has an article in the New York Times in which he repeats his view that, quote, impeachment requires a crime. But he now argues that the articles of impeachment do charge crimes. He is simply wrong. He is wrong because in the United States versus Hudson, a case decided almost more than 200 years ago now, the United States Supreme Court ruled that federal courts have no jurisdiction to create common law crimes. Crimes are only what are in the statute book. So Professor Bowie is right that the Constitution requires a crime for impeachment, but wrong when he says that common law crimes can be used as a basis for impeaching even though they don't appear in the statute books. Now, I'm not here arguing that the current distinguished members of the Senate are in any way bound, legally bound, by Justice Curtis's arguments or those of Dean Dwight. But I am arguing that you should give them serious consideration, the consideration to which they are entitled by the eminence of their author and the role they may have played in the outcome of the closest precedent to the current case. Now, I want to be clear, there's a nuanced difference between the arguments made by Curtis and Dwight and the argument that I am presenting here today, based on my reading of history. Curtis argued that there must be a specific violation of pre-existing law. He recognized that at the time of the Constitution, there were no federal criminal statutes. Of course not. The Constitution established the national government, so we couldn't have statutes prior to the establishment of our Constitution and our nation. This argument is offered today by proponents of this impeachment on the claim that framers could not have intended to limit the criteria for impeachment to criminal-like behavior. Justice Curtis addressed that issue and that argument head-on. He pointed out that crimes such as bribery would be made criminal by the laws of the United States, which the framers of the Constitution knew would be passed. In other words, he anticipated that Congress would soon enact statutes punishing and defining crimes such as burglary, extortion, perjury, etc. He anticipated that, and he based his argument in part on that. The Constitution already included treason as a crime, and that was defined in the Constitution itself. And then it included other crimes. But what Justice Curtis said is that you could include laws written or unwritten, express or implied, by which he meant common law, which at the time of the Constitution, there were many common law crimes, and they were enforceable, even federally, until the Supreme Court, many years later, decided that common law crimes were no longer part of federal jurisdiction. So the position that I've derived from the history would include, and this is a word that has upset some people, but would include criminal-like conduct akin to treason and bribery. There need not be, in my view, conclusive evidence of a technical crime that would necessarily result in a criminal conviction. Let me explain. For example, if a president were to receive or give a bribe outside of the United States and outside of the statute of limitations, he could not technically be prosecuted in the United States for such a crime. But I believe he could be impeached for such a crime because he committed the crime of bribery, even though he couldn't technically be accused of it in the United States. That's the distinction that I think we draw. Or if a president committed extortion, perjury, or obstruction of justice, he could be charged with these crimes as impeachable offenses because these crimes, though not specified in the Constitution, are akin to treason and bribery. This would be true even if some of the technical elements, time and place, were absent. What Curtis and Dwight and I agree upon, and this is the key point in this impeachment case, please understand what I'm arguing, is that purely non-criminal conduct, including abuse of power and obstruction of Congress, are outside the range of impeachable offenses. That is the key argument I'm presenting today. This view was supported by text writers and judges close in time to the founding. William Oldwell Russell, whose 1819 treatise on criminal law was a Bible among criminal law scholars and others, defined high crimes and misdemeanors as, quote, such immoral and unlawful acts as are nearly allied and equal in guilt to a felony, and yet, owing to the absence of some technical circumstances, do not fall within the definition of a felony. Similar views were expressed by some state courts, others disagreed. Curtis considered views, and those of Dwight, Russell, and others, based on careful study of the text and history, are not bonkers, absurdist, legal claptrap, or other demeaning epithets thrown around by partisan supporters of this impeachment. As Judge Starr pointed out, they had the weight of authority. They were accepted by the generation of founders and the generations that followed. If they are not accepted by academics today, that shows a weakness among the academics, not among the founders. These who disagree with Curtis's textual analysis are obliged, I believe, to respond with reasoned counter-interpretations, not name-calling. If Justice Curtis's arguments and those of Dean Dwight are rejected, I think then proponents of impeachment must offer alternative principles, alternative standards for impeachment and removal. We just heard that in 1970, Congressman Gerald Ford, who I greatly admired, said the following: in the context of an impeachment of a justice, an impeachable offense is whatever a majority of the House of Representatives considered it to be at a given moment in history, etc. You all know the quote. Congresswoman Maxine Waters recently put it more succinctly in the context of a presidential impeachment. Here's what she said: impeachment is whatever Congress says it is. There is no law. But this lawless view would place Congress above the law. It would place Congress above the Constitution. For Congress to ignore the specific words of the Constitution itself and substitute its own judgments would be for Congress to do what it is accusing the president of doing. And no one is above the law, not the president and not Congress. This is precisely the kind of view expressly rejected by the framers, who feared having a president serve at the pleasure of the legislature And it is precisely the view rejected by Senator James Grimes when he refused to accept an interpretation of high crimes and misdemeanors that would change according to the law of each senator's judgment enacted in his own bosom. The Constitution requires, in the words of Gouverneur Morris, that the criteria for impeachment must be enumerated and defined. Those who advocate impeachment today are obliged to demonstrate how the criteria accepted by the House in this case are enumerated and defined in the Constitution. The compelling textual analysis provided by Justice Curtis is confirmed by the debate in the Constitutional Convention, by the Federalist Papers, by the writings of William Blackstone, and I believe by the writings of Alexander Hamilton, which were heavily relied on by lawyers at the time of the Constitution's adoption. There were, at the time of the Constitution's adoption, two great debates that went on, and it's very important to understand the distinction between these two great debates. The first, hard to imagine today, but the first was, should there be any power to impeach a president at all? And there were several members of the founding generation and of the framers of the Constitution who said no, a president shouldn't be allowed to be impeached. The second is very, very important in our consideration today, is if a president is to be subject to impeachment, what should the criteria be? These are very different issues, and they are often erroneously conflated. Let's begin with the first debate. During the broad debate about whether a president should be subject to impeachment, proponents of impeachment used vague and open-ended terms such as unfit, obnoxious, corrupt, misconduct, misbehavior, negligence, malpractice, perfidy, treachery, incapacity, peculation, and maladministration. They worry that a president might, quote, pervert his administration into a scheme of speculation and oppression, that he might be corrupted by foreign influence, and yes, this is important, that he might have great opportunities of abusing his power. Those were the concerns that led the framers to decide that a president must be subject to impeachment. But not a single one of the framers suggested that these general fears, justifying the need for an impeachment and removal mechanism, should automatically be accepted as a specific criterion for impeachment. Far from it, as Gouverneur Morris aptly put it, corruption and some other offenses ought to be impeachable, but the cases ought to be enumerated and defined. The great fallacy of many contemporary scholars and pundits, and with due respect, members of the House of Representatives, is that they fail to understand the critical distinction between the broad reasons for needing an impeachment mechanism and the carefully enumerated and defined criteria that should authorize the deployment of this powerful weapon. Let me give you a hypothetical example that might have faced Congress, or certainly will face Congress. Let's assume that there is a debate over regulating the content of social media, whether we should have regulations or criminal, civil regulations over Twitter or Facebook, etc. In the debate over regulating the social media, proponents of regulation might well cite broad dangers, such as false information, inappropriate content, hate speech. Those are good reasons for having regulation. But when it came to enumerating and defining what should be prohibited, such broad dangers would have to be balanced against other important policies, and the resulting legislation would be much narrower and more carefully defined than the broad dangers that necessitated some regulation. The framers understood and acted on this difference, but I'm afraid that many scholars and others and members of Congress fail to see this distinction, and they cite some of the fears that led to the need for impeachment mechanism. They cite them as the criteria themselves. That is a deep fallacy, and it's crucially important that the distinction be sharply drawn between arguments made in favor of impeaching and the criteria then decided upon to justify the impeachment specifically of a president. The framers understood this, and so they got down to the difficult business of enumerating and defining precisely which offenses among the many that they feared a president might commit should be impeachable, as distinguished from those left to the voters to evaluate. Some framers, such as Roger Sherman, wanted the president to be removable by the national legislature at its pleasure, much like the British Prime Minister can be removed by a simple vote of no confidence by Parliament. That view was rejected. Benjamin Franklin opposed decidedly the making of the executive, quote, the mere creature of the legislature. Gouverneur Morris was against the dependence of the executive on the legislature, considering the legislature, you will pardon me quoting this, a great danger to be apprehended. I don't agree with that. James Madison expressed concerns about the president being improperly dependent on the legislature. Others worried about a feeble executive. Hearing these and other arguments against turning the new republic into a parliamentary democracy in which the legislature had the power to remove the president, the framers set out to strike the appropriate balance between the broad concerns that led them to vote for a provision authorizing the impeachment of the president and the need for specific criteria not subject to legislative abuse or overuse. Among the criteria proposed were malpractice, neglect of duty, malconduct, neglect in the execution of office, and this word we'll come back to talk about, maladministration. It was a response to that last term, a term used in Britain as a criteria for impeachment, that Madison responded, so vague a term will be equivalent to a tenure during the pleasure of the Senate. Upon hearing Madison's objections, Colonel Mason withdrew maladministration and substituted other high crimes and misdemeanors. Had a delegate proposed inclusion of abuse of power or obstruction of Congress as enumerated and defined criteria for impeachment, history strongly suggests that Madison would have similarly opposed it, and it would have been rejected. I will come back to that argument a little later on when I talk specifically about abuse of power. Indeed, Madison worried that a partisan legislature could even misuse the word misdemeanor to include a broad array of non-crimes, so he proposed moving the trial to the nonpartisan Supreme Court. The proposal was rejected. Now, this does not mean, as some have suggested, that Madison suddenly changed his mind and favored such misuse to expand the meaning of misdemeanor to include broad terms like misbehavior. No. It only meant that he feared it. He feared that the word misdemeanor could be abused. His fears proven to be prescient by the misuse of that term, high crimes and misdemeanors, by the House in this case. Now, the best evidence that the broad concerns cited by the framers to justify impeachment were not automatically accepted as criteria justifying impeachment is the manner by which the word incapacity, focus on that word please, incapacity, was treated. Madison and others focused heavily on the problem of what happens if a president becomes incapacitated. Certainly a president who's incapacitated should not be allowed to continue to preside over this great country. And everyone seemed to agree that the possibility of presidential incapacity is a good and powerful reason for having an impeachment provision. But when it came time to establishing criteria for actually removing a president, incapacity was not included. Why not? Presumably because it was too vague and subjective a term. And when we had an incapacitated president, in the end of the Woodrow Wilson second term, he was not impeached and removed. A constitutional amendment with carefully drawn procedural safeguards against abuse was required to remedy the daunting problem of a president who was deemed incapacitated. Now, another reason why incapacitation was not included among impeachable offenses because it's not criminal. It's not a crime to be incapacitated. It's not akin to treason. It's not akin to bribery. And it's not a high crime and misdemeanor. The framers believed that impeachable offenses must be criminal in nature and akin to the most serious crimes, incapacity simply did not fit into this category. Nothing criminal about it. So the Constitution had to be amended to include a different category of non-criminal behavior that warranted removal. I urge you to consider seriously that important part of the history of the adoption of our Constitution. I think that Blackstone and Hamilton also support this view. There's no disagreement over the conclusion that the words treason, bribery, or other high crimes, those words require criminal behavior. The debate is only over the words and misdemeanors. The framers of the Constitution were fully cognizant of the fact that the word misdemeanor was a species of crime. The book that was most often deemed authoritative was written by William Blackstone in Great Britain. And here is what he says about this in the version that was available to the framers. A crime or misdemeanor is an act committed or omitted in violation of a public law, either forbidding or commanding it. The general definition comprehends both crimes and misdemeanors, which, properly speaking, are mere synonymous terms. Mere synonymous terms. He then went on, though in common usage the word crimes is made to denote such offenses are of a deeper and more outrageous dye, while smaller faults and omissions of less consequence are comprised under the gentler name of misdemeanors only. Interestingly, though, he pointed out that misdemeanors were not always so gentle. There was a category called capital misdemeanors, where if you stole somebody's pig or other fowl, you could be sentenced to death, but it's only for a misdemeanor, don't worry. It's not for a felony, but there were misdemeanors that were capital in nature. Moreover, Blackstone wrote that parliamentary impeachment, quote, is a prosecution of already known and established law presented to the most high and supreme court of criminal jurisdiction, analogous to this great court. He observed that a commoner can be impeached but only for high misdemeanors. A peer may be impeached for any crime, any crime. This certainly suggests that Blackstone deemed high misdemeanors to be a species of crime. Hamilton is a little less clear in this issue, and not surprisingly, because he was writing in Federalist number 65, he was writing not to define what the criteria for impeachment were. He was writing primarily in defense of the Constitution as written, and less to define its provisions. But he certainly cannot be cited in favor of criteria such as abuse of power or obstruction of Congress, nor of impeachment voted along party lines. He warned that the greatest danger, these were his words, the greatest danger is that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. In addition to using the criminal terms innocence or guilt, Hamilton also referred to, quote, prosecution and sentence. He cited the constitutional provisions that states that the party convicted shall nevertheless be liable and subject to a criminal trial as a reason for not having the president tried before the Supreme Court. He feared a double prosecution, a variation of double jeopardy, before the same judiciary. These points all sound in criminal terms. But advocates of a broad, open-ended, non-criminal interpretation of high crimes and misdemeanors insist that Hamilton is on their side. And they cite the following words regarding the court of impeachment. And I think I've heard these words quoted more than any other words in support of a broad view of impeachment, and they are misunderstood. Here's what he said when describing the court of impeachment. He said, the subjects of its jurisdiction, those are important words, the subjects of its jurisdiction, by which he meant treason, bribery, and other high crimes and misdemeanors, the subjects of its jurisdiction are those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust. They are of a nature which may with peculiar propriety be denominated political, as they relate chiefly to injuries done immediately to society itself. Those are Hamilton's words. They're often misunderstood as suggesting that the criteria authorizing impeachment include the misconduct of public men, or the abuse or violation of some public trust. That is a misreading. These words were used to characterize the constitutional criteria that are the subject of the jurisdiction of the Court of Impeachment, namely treason, bribery, or other high crimes and misdemeanors. Those specified crimes are political in nature. They are the crimes that involve the misconduct of public men and the abuse or violation of some public trust. Hamilton was not expanding the specified criteria to include as independent grounds for impeachment misconduct, abuse, or violation. If anything, he was contracting them to require, in addition to proof of the specified crimes, also proof that the crime must be of a political nature. This would exclude President Clinton's private, non-political crime. In fact, and this is interesting, Hamilton's view was cited by Clinton's advocates as contracting, not expanding, the meaning of high crimes. Today, some of these same advocates, you look at the same words and cite them as expanding its meaning. Clinton was accused of a crime, perjury. And so the issue in his case was not whether the Constitution required a crime for impeachment. Instead, the issue was whether Clinton's alleged crime could be classified as a high crime in light of its personal nature. During the Clinton impeachment, I stated in an interview that I did not think that a technical crime was required, but that I did think that abusing trust could be considered. I said that. At that time, I had not done the extensive research on that issue because it was irrelevant to the Clinton case, and I was not fully aware of the compelling counter arguments. So I simply accepted the academic consensus on an issue that was not on the front burner at the time. But because this impeachment directly raises the issue of whether criminal behavior is required, I have gone back and read all the relevant historical material, as nonpartisan academics should always do, and have now concluded that the framers did intend to limit the criteria for impeachment to criminal-type acts akin to treason, bribery, and they certainly did not intend to extend it to vague and open-ended and non-criminal accusations such as abuse of power and obstruction of Congress. I published this academic conclusion well before I was asked to present the arguments to the Senate in this case. My switch in attitude, purely academic, purely nonpartisan. Nor am I the only participant in this proceeding who has changed his mind. Several members of Congress, several senators, expressed different views regarding the criteria for impeachment when the subject was President Clinton than they do now. When the president was Clinton, my colleague and friend, Professor Lawrence Tribe, who is advising Speaker Pelosi now, wrote that a sitting president could not be charged with a crime. Now he's changed his mind. That's what academics do and should do based on new information. If there are reasonable doubts about the intended meaning of high crimes and misdemeanors, senators might consider resolving these doubts by reference to a legal concept known as lenity. Lenity goes back to hundreds of years before the founding of our country and was a concept in Great Britain relied upon by many of our own justices and judges over the years. It was well known to the legal members of the founding generation. It required that in construing a criminal statute that is capable of more than one reasonable interpretation, the interpretation that favors the defendant should be selected unless it conflicts with the intent of the statute. It has been applied by Chief Justice Marshall, Justice Oliver Wendell Holmes, Frankfurter, Felix Frankfurter, Justice Antonin Scalia, and others. Now, applying that rule to the interpretation of high crimes and misdemeanors would require that these words be construed narrowly to require criminal-like conduct akin to treason and bribery, rather than broadly to encompass abuse of power and obstruction of Congress. In other words, if senators are in doubt about the meaning of high crimes and misdemeanors, the rule of lenity should incline them toward accepting a narrower rather than a broad interpretation, a view that rejects abuse of power and obstruction of Congress as within the constitutional criteria. Now, even if the rule of lenity is not technically applicable to impeachment, that's a question, certainly the policies underlying that rule are worthy and deserving of consideration as guides to constitutional interpretation. Now, here I'm making, I think, a very important point. Even if the Senate were to conclude that a technical crime is not required for impeachment, the critical question remains, and it's the question I now want to address myself to, do abuse of power and obstruction of Congress constitute impeachable offenses? The relevant history answers that question clearly in the negative. Each of these charges suffers from the vice of being, quote, so vague a term that they will be equivalent of tenure at the pleasure of the Senate, to quote, again, the father of our Constitution. Abuse of power is an accusation easily leveled by political opponents against controversial presidents. In our long history, many presidents have been accused of abusing their power. I will now give you a list of presidents who in our history have been accused of abusing their power, who would be subject to impeachment under the House manager's view of the Constitution. George Washington, refusal to turn over documents related to the Jay Treaty. John Adams, signing and enforcing the Alien and Sedition laws. Thomas Jefferson, purchasing Louisiana without congressional authorization. I'll go on. John Quincy Adams, Martin Van Buren, John Tyler, arbitrary, despotic, and corrupt use of the veto power. James Polk, here I quote Abraham Lincoln. Abraham Lincoln accused Polk of abusing his power of his office, contemptuously disregarding the Constitution, usurping the role of Congress, and assuming the role of dictator. He didn't seek to impeach him, he just sought to defeat him. Abraham Lincoln was accused of abusing his power for suspending the writ of habeas corpus during the Civil War. President Grant, Grover Cleveland, William McKinley, Theodore Roosevelt, William Taft, Woodrow Wilson, Franklin Roosevelt, Harry Truman, Jimmy Carter, Ronald Reagan, quote, concerning Iran-Contra, then now I say, Professor Lawrence Tribe said the following, quote, therein lies what appears to be the most serious breach of duty by the president, a breach that may well entail an impeachable abuse of power. George H.W. Bush. The following was released today by the Clinton-Gore campaign. In the past weeks, Americans have begun to learn the extent to which George Bush and his administration have abused their governmental power for political purposes. That's how abuse of power should be used, as campaign rhetoric. It should be in statements issued by one political party against the other. That's the nature of the term. Abuse of power is a political weapon, and it should be leveled against political opponents. Let the public decide. That's true. Barack Obama, the House Committee on the Judiciary, held an entire hearing entitled Obama Administration's Abuse of Power. Now, by the standards applied to earlier presidents, nearly any controversial act by a chief executive could be denominated abuse of power. For example, past presidents have been accused of using their foreign policy, even their war powers, to enhance their electoral prospects. Presidents often have mixed motives that include partisan, personal benefits, along with the national interest. Professor Josh Blackman, constitutional law professor, provided the following interesting example. Quote, in 1864, during the height of the Civil War, President Lincoln encouraged General William Sherman to allow soldiers in the field to return to Indiana to vote. What was Lincoln's primary motivation, the professor asks. He wanted to make sure that the government of Indiana remained in the hands of Republican loyalists who would continue the war until victory. Lincoln's request risked undercutting the military effort by depleting the ranks. Moreover, during this time, soldiers from the remaining states faced greater risks than did the returning Hoosiers. The professor continues, Lincoln had dueling motives. Privately, he sought to secure victory for his party. But the president, as a president and as a party leader and commander-in-chief, made a decision with life or death consequences, end quote. Professor Blackman drew the following relevant conclusion from this and other historical events. He said, politicians routinely promote their understanding of the general welfare while in the back of their minds considering how these actions will affect their popularity. Often the two concepts overlap. What's good for the country is good for the official's re-election. All politicians, he said, understand that dynamic. Like all human beings, presidents and other politicians persuade themselves that their actions, seen by their opponents as self-serving, are primarily in the national interest. In order to conclude that such mixed motive actions constitute an abuse of power, opponents must psychoanalyze the president and attribute to him a singular, self-serving motive. Such a subjective probing of motives cannot be the legal basis for a serious accusation of abuse of power that could result in the removal of an elected president. Yet, this is precisely what the managers are claiming. Here's what they said. Quote, whether the president's real reason, the ones actually in his mind, are at the time legitimate. What a standard. What was in the president's mind, actually in his mind? What was the real reason? Would you want your actions to be probed for what was the real reason why you acted? Even if a president were, and it clearly shows, in my mind, that the framers could not have intended this psychoanalytic approach to presidential motives to determine the distinction between what is impeachable and what is not. And here I come to a relevant and contemporaneous issue. Even if a president, any president, were to demand a quid pro quo as a condition to sending aid to a foreign country, obviously a highly disputed matter in this case, that would not by itself constitute an abuse of power. Consider the following hypothetical case that is in our news today as the Israeli Prime Minister comes to the United States for meetings. Let's assume a Democratic president tells Israel that foreign aid authorized by Congress will not be sent, or an Oval Office meeting will not be scheduled unless the Israelis stop building settlements. Quid pro quo. I might disapprove of such a quid pro quo demand on policy grounds, but it would not constitute an abuse of power. Quid pro quo alone is not a basis for abuse of power. It's part of the way foreign policy has been operated by presidents since the beginning of time. The claim that foreign policy decisions can be deemed abuses of power based on subjective opinions about mixed or sole motives, that the president was interested only in helping himself, demonstrate the dangers of employing the vague, subjective, and politically malleable phrase abuse of power as a constitutionally permissible criteria for the removal of a president. Now, it follows from this that if a president, any president, were to have done what the Times reported about the content of the Bolton manuscript, that would not constitute an impeachable offense. Let me repeat, nothing in the Bolton revelations, even if true, would rise to the level of an abuse of power or an impeachable offense. That is clear from the history, that is clear from the language of the Constitution. You cannot turn conduct that is not impeachable into impeachable conduct simply by using words like quid pro quo and personal benefit. It is inconceivable that the framers would have intended so politically loaded and promiscuously deployed a term as abuse of power to be weaponized as a tool of impeachment. It is precisely the kind of vague, open-ended, and subjective term that the framers feared and rejected. Consider the term maladministration. I want to get back to that term because it's the term that was explicitly rejected by the framers. You'll recall it was raised, and then Madison objected to it. It was then withdrawn, and it is not part of the criteria. We all agree that maladministration is not a ground for impeachment. If the House were to impeach on maladministration, it would be placing itself above the law. There's no doubt about that because the framers explicitly rejected maladministration. Now, what is maladministration? It's comparable in many ways to the abuse of power. Maladministration has been defined to include abuse, corruption, misrule, dishonesty, misuse of office, and misbehavior. Professor Bowie, in his article in today's New York Times, equates abuse of power with, quote, misconduct in office. Misconduct in office, thus supporting the view that when the framers rejected maladministration, they also rejected abuse of power as a criteria for impeachment. Blackstone denominated maladministration as a high misdemeanor that is punishable by the method of parliamentary impeachment, wherein such penalties short of death are inflicted. He included among those imprisonment. In other words, you could be imprisoned for maladministration. Despite this British history, Madison insisted that it be rejected as a constitutional criteria for impeachment because, and I quote again, so vague a term will be equivalent to tenure during the pleasure of the Senate. And it was explicitly rejected and withdrawn by its sponsor. This important episode in our constitutional history supports the conclusion that the framers did not accept whole hog the British approach to impeachment, as some have mistakenly argued. Specifically, they rejected vague and open-ended criteria, even those carrying punishment of imprisonment in Britain, because they did not want to turn our new republic into a parliamentary-style democracy in which the chief executive can be removed from office simply by a vote of non-confidence. That's what they didn't want. Sure, nobody was above the law, but they created a law. They created a law by which Congress could impeach, and they did not want to expand that law to include all the criteria that permitted impeachment in Great Britain. The framers would never have included and did not include abuse of power as an enumerated and defined criteria for impeachment. By expressly rejecting maladministration, they implicitly rejected abuse. Nor would the framers have included obstruction of Congress as among the enumerated and defined criteria. It too, vague, indefinable, especially in a constitutional system in which, according to Hamilton in Federalist 78, the legislative body is not themselves the constitutional judge of their own powers, and the construction they put on them is not conclusive upon other departments. Instead, he said, the courts were designed as an intermediate body between the people, as declared in the Constitution, and the legislature in order to keep the latter within the limits assigned to their authority. Under our system of separation of powers and checks and balances, it cannot be an obstruction of justice, and some other lawyers have made this argument today more thoroughly, for a president to demand judicial review of legislative subpoenas before they are complied with. The legislature is not the constitutional judge of its own powers, including the power to issue subpoenas. The courts were designated to resolve disputes between the executive and legislative branches, and it cannot be an obstruction of Congress to invoke the constitutional power of the courts to do so. By their very nature, words like abuse of power and obstruction of Congress are standardless. It's impossible to put standards into words like that. Both are subjective matters of degree and amenable to varying partisan interpretations. It's impossible to know in advance whether a given action will subsequently be deemed to be on one side or the other of the line. Indeed, the same action with the same state of mind can be deemed abusive or obstructive when done by one person, but not when done by another. That is the essence of what the rule of law is not. When you have a criteria that could be applied to one person in one way and another person another way, and they both fit within the terms abuse of power. A few examples will illustrate the dangers of standardless impeachment criteria. My friend and colleague, Professor Noah Feldman, has argued that a tweet containing what he believed was false information could, quote, get the current president impeached if it is part of a broader course of conduct, a tweet. Professor Alan Lichtman has argued that the president could be impeached based on his climate change policy, which he regards as a crime against humanity. I have to tell you, I disagree with our president's climate change policy, as I do with many of his other policies. But that's not a criteria for impeachment. That's a criteria for deciding who you're going to vote for. If you don't like a president's policies on climate change, vote for the other candidate. Find a candidate who has better policies on climate change. If you don't like a president's tweets, find somebody who doesn't tweet. That will be easy. But don't allow your subjective judgments to determine what is and is not an impeachable offense. Professor Tribe, as I mentioned, argued that under the criteria of abuse of power, President Ronald Reagan should have been impeached. Would any American today accept a legal system in which prosecutors could charge a citizen with abusive conduct? Can you imagine a crime? Abusive conduct? Fortunately, we have constitutional protections against a statute that, quote, either forbids or requires the doing of an act in terms so vague that men and women of common intelligence must necessarily guess at its meaning and differ as to its application. Very difficult to imagine criteria that fit this description of what the Supreme Court has said violates the first essentials of due process more closely than abuse of power and obstruction of Congress. Another constitutional rule of construction is that when words can be interpreted in an unconstitutionally vague manner or in a constitutionally precise manner, the latter must be chosen. You are entitled to use that rule of interpretation as well in deciding whether or not obstruction of Congress or abuse of power can be defined as fitting within the criteria of high crimes and misdemeanors. For the Senate to remove a duly elected president on vague, non-constitutional grounds, such as abuse of power or obstruction of Congress, would create a dangerous precedent and be construed, in the words of Senator James N. Grimes, into approval of impeachment as part of future political machinery. This is a realistic threat to all future presidents who serve with opposing legislative majorities that could easily concoct vague charges of abuse or obstruction. The fact that a long list of presidents that were accused of abuse of power were not impeached demonstrates how selectively this term has and can be used in the context of impeachment. I'm sorry, House managers, you just picked the wrong criteria. You picked the most dangerous possible criteria to serve as a precedent for how we supervise and oversee future presidents. The idea of abuse of power and obstruction of Congress are so far from what the framers had in mind that they so clearly violate the Constitution and would place Congress above the law. Now, nor are these vague, open-ended, and unconstitutional articles of impeachment that were charged here, they're not saved by the inclusion in these articles of somewhat more specific but still non-criminal type conduct. The specifications are themselves vague, open-ended, and do not charge impeachable offenses. They include such accusations as compromising national security, abusing the power of the presidency, violating his oath of office. In any event, it's the actual articles that charge abuse of power and obstruction of justice, neither of which are in the Constitution. It's the actual articles on which you must all vote, not on the more specific list of means included in the text of the articles. An analogy to a criminal indictment might be helpful. If a defendant were accused of dishonesty, committing the crime of dishonesty, it wouldn't matter that the indictment listed as well the means toward dishonesty a variety of far more specific potential offenses. Dishonesty is simply not a crime. It's too broad a concept. It's not in the statutes. It's not a crime. The indictment would be dismissed because dishonesty is a sin and not a crime, even if the indictment included a long list of more specific acts of dishonesty. Nor can impeachment be based on a bunching together of non-impeachable sins, none of which standing alone meet the constitutional criteria. Only if at least one constitutionally authorized offense is proved can the Senate then consider other conduct in deciding the discretionary issue of whether removal is warranted. In other words, your jurisdiction is based on commission of an impeachable offense. Once that jurisdictional element is satisfied, you have broad discretion to determine whether removal is warranted, and you consider a wide array of conduct, criminal and non-criminal. But you have no jurisdiction to remove unless there is at least one impeachable offense within the meaning of high crimes and misdemeanors. In the 3 days of argument, the House managers tossed around words even vaguer and more open-ended than abuse and obstruction to justify their case for removal. Included trust, truth, honesty, and finally, right. These aspirational words of virtue are really important, but they demonstrate the failure of the managers to distinguish alleged political sins from constitutionally impeachable offenses. We all want our presidents and other public officials to live up to the highest standards set by Washington and Lincoln, though both of them were accused of abuse of power by their political opponents. The framers could have demanded that all presidents must meet Congressman Schiff's standards of being honest, trustworthy, virtuous, and right in order to complete their terms. But they didn't, because they understand human fallibility. As Madison put it, if men were angels, no government would be necessary. And then, speaking of presidents and other public officials, if angels were to govern men, neither internal nor external controls on government would be necessary. The framers understood that if they set the criteria for impeachment too low, few presidents would serve their terms. Instead, their tenure would be at the pleasure of the legislature, as it was and still is in Britain. So they set the standards and the criteria high, requiring not sinful behavior, not dishonesty, distrust, or dishonor, but treason, bribery, or other high crimes and misdemeanors. I end this presentation today with a non-partisan plea for fair consideration of my arguments and those made by counsel and managers on both sides. I willingly acknowledge that the academic consensus is that criminal conduct is not required for impeachment and that abuse of power and obstruction of Congress are sufficient. I have read and respectfully considered the academic work of my many colleagues who disagree with my view and the few who accept it. I do my own research and I do my own thinking, and I have never bowed to the majority on intellectual or scholarly matters. What concerns me is that during this impeachment proceeding, there have been few attempts to respond to my arguments and other people's arguments opposed to the impeachment of this president. Instead of answering my arguments and those of Justice Curtis and Professor Bowie and others on their merits and possible demerits, they have simply been rejected with negative epithets. I urge the senators to ignore these epithets and to consider the arguments and counter-arguments on their merits, especially those directed against the unconstitutional vagueness of abuse of power and obstruction of Congress. I now offer a criteria for evaluating conflicting arguments. The criteria that I offer, I have long called the shoe on the other foot test. It is a colloquial variation of the test proposed by the great legal and political thinker and my former colleague, John Rawls. It is simple in its statement, but difficult in its application. As a thought experiment, I respectfully urge each of you to imagine that the person being impeached were of the opposite party of the current president, but that in every other respect, the facts were the same. I have applied this test to the constitutional arguments I am offering today. I would be making the same constitutional arguments in opposition to the impeachment on these two grounds, regardless of whether I voted for or against the president, and regardless of whether I agreed or disagreed with his or her policies. Those of you who know me know that that is the absolute truth. I am nonpartisan in my application of the Constitution. Can the same be said of all of my colleagues who support this impeachment, especially those who oppose the impeachment of President Bill Clinton? I first proposed the shoe test 20 years ago when evaluating the Supreme Court's decision in Bush versus Gore, asking the justices to consider how they would have voted had it been candidate Bush rather than Gore, who was several hundred votes behind and seeking a recount. In other words, I was on the other side of that issue. I thought the Supreme Court in that case favored the Republicans over the Democrats, and I asked them to apply the shoe on the other foot test. I now respectfully ask this distinguished chamber to consider that heuristic test in evaluating the arguments you have heard in this historic chamber. It is an important test because how you vote on this case will serve as a precedent for how other senators of different parties, different backgrounds, and different perspectives vote in future cases. Allowing a duly elected president to be removed on the basis of the standardless, subjective, ever-changing criteria, abuse of power, and obstruction of Congress risks being construed, in the words of Senator Grimes, a Republican senator from Iowa who voted against impeaching President Andrew Johnson, into approval of impeachments as part of future political machinery. As I begin, I will close. I am here today because I love
At this time, I yield 1 minute to the gentleman from California, Mr. McCarthy.
Gentleman's recognized.
Thank you, Madam Speaker. Back when this national nightmare began, Speaker Pelosi laid bare her intentions and purely partisan agenda. She told her caucus that they needed to strike while the iron is hot.
Get on.
This was always an exercise in raw partisan politics. Contrary to the warnings of our founders, and over the last month, we saw the justification for running the fastest, thinnest, and weakest impeachment in American history crumble. Instead of sending the articles of impeachment to the Senate for trial, Speaker Pelosi held them hostage in a failed play to gain leverage that she did not and would never have. In terms of concessions, she got nothing. No control, no moral victories. In other words, another failed strategy. After a month of counterproductive and harmful delays, I have 3 questions for my friends on the other side of the aisle, the Democrats. What happened to impeachment being urgent? What happened to Congress being on the clock? What happened to saying the House would be derelict in our duty if we did not act immediately? These were all the assertions Democrats made over the past several months. I guess it turns out none of them are true. These delay tactics were self-serving, hypocritical, and discrediting. But they made an important admission. Some might even call it a concession. You proved a very big point. Democrats do not even believe their case was robust enough to win in a trial.
Yep.
Even the Speaker's allies admit the delays undermined their case. Some has gone as far as describing it as a failed strategy. These are those who are closest to her. Senator Feinstein, the senior Democrat from our state of California and the hometown senator of the Speaker, said, "The longer it goes on, the less urgent it becomes." And Chairman Adam Smith, a confidant of the Speaker, said it was time to transmit the articles to the Senate. Before these statements were made last week, before the Speaker relented, they are significant because they were public and they were honest. I'm disappointed these individuals did not have the courage to stand by their initial comments. If impeachment was truly as urgent as Democrats claimed, the majority should not have waited for the Speaker to choose a political convenient time. Anyone could have recognized this ploy would not work. The House and the Senate are different institutions.
Yep.
And at this point in time, controlled by different parties. As James Madison wrote in the Federalist Papers, the purpose of bicameralism is to guard against the dangers of encroachment and to stop toxic resolutions from taking effect. We saw separation of powers prevail against an abuse of power, just as the Constitution intends. The idea of withholding a sloppy impeachment case to force the Senate to change its rules is constitutionally and politically unheard of. Frankly, it's just ridiculous. In Article 1, Section 5, the Constitution clearly states, each House may determine the roles of its proceedings. It doesn't say the House may determine the roles of proceedings in the Senate. If anything, the Speaker's actions have only further persuaded members of the Senate that the evidence of impeachment was neither thorough nor satisfactory. But you know what? Let's be honest. This was never about persuasion. It was never about the rule of law. It was what Alexander Hamilton warned us. That one party would get control. And just because of the animosity would demean the process of impeachment. And by selecting these particular batch of managers, the Speaker has further proven she's not interested in winning the minds, the hearts, or even following the Constitution. Let's take a look at the first 3 names Speaker Pelosi announced in her anticipated announcement earlier today. Chairman Schiff, a man who has already taken on the role of judge, jury, and fact witness throughout the entire House impeachment process. Chairman Nadler, someone who campaigned for the chairmanship of the Judiciary Committee that's responsible for impeachment beginning as far back as December 2017, before you were even in the majority, on the notion that he would be the best person to lead the charge on potential impeachment against the president. You see, you get a chairmanship by your conference voting for you. You campaign for it. You put your best ideas out there of why you should be the chairman. In 2017, that was the campaign. Congressman Hakeem Jeffries, a member who almost 2 years to this date voted in support of impeachment. You know, that was more than a year before the Ukraine call even took place. Those are just some of the managers. If you think about the members, there's people who were, on the day they were sworn in to this body, told those who supported him the greatest that they were going to impeach him. As I've said in the past, there's an issue with fairness. But instead of looking to the Senate, Speaker Pelosi should be looking within her own caucus. From the beginning, this investigation was marred by selective leaks to the media, a completely predetermined process. Yes, we've been through impeachment before, but it was much different. We believed in the rule of law back then, that we would face our accuser, that you could cross-examine, that the minority could actually ask for witnesses. The day that impeachment was asked to come forward, I sent a letter to the Speaker, laying out 10 items, none that were made up. You know what they were? The fair process we've always used in the past. The answer was no. Because they've been working on this for 2.5 years, they could not let fairness determine the outcome. Any other prosecutor would be disbarred for such blatant bias, especially if that prosecutor was a fact witness in the case. The reason for this impeachment is the same reason it's taken Democrats 30 days to send the articles to the Senate. Just spite. They wanted to stain the president's record without giving him a fair chance to clear his name. Last year we saw House Democrats invert the burden of proof during their fair investigation. For every American watching, take for instance if this was your government, if you switched the burden of proof on you. We have a congressman, Max Rose, characterized it this way, this new freshman of the majority. The president says he's innocent, so all we're saying is prove it. God forbid government accuses you of something as an average American, say you have to prove it. We just switched a fundamental belief as an American. But only in this house do we do that. This guilty and proven innocent mentality was an admission that impeachment was not about upholding justice or protecting the rule of law. Now Democrats have invented an even more destructive standard. You're guilty because they say so. Our founders feared this day. Alexander Hamilton warned us of this day. I'd hoped this day would not come. I would hope those who uphold the Constitution would believe in the rule of law instead of the spite of the dislike of an individual. Like the kangaroo courts on college campuses, or an accusation is enough for a conviction. Even as early as just last Sunday in an interview, Speaker Pelosi made that point very clear to all of us. Asked what a Senate acquittal would mean, she said it didn't matter. The president is impeached forever. Is that what this is all about?
Yep.
Just a personality. Just an abuse of power that you have within a house that we all feared this country would never do. You could almost see on the speaker's smile as she spoke about this new standard, how incredibly solemn she was. Madam Speaker, when Americans look back on this sad saga, they will see a rigged process that forever damaged the remedy of impeachment. Speaker Pelosi got nothing from the Senate, but the American people got worse than nothing. They got stuck with the bill for a costly, never-ending investigation. The old saying that you get what you pay for does not apply here. Congress wasted time and millions of dollars on partisan impeachment. In return, taxpayers get nothing. Democrats' misaligned priorities have cost the people solutions that could have improved the quality of their life. There's no greater contrast than what we are doing right here today than what is happening at Pennsylvania Avenue. The president sitting down with another country of a leader and signing a trade agreement. Something people said we could never get done. To make this country stronger, to make America the next century ours. But what are we doing here? We are doing what this majority has worked their entire time for. Before they were even sworn in, they campaigned for the position of chairman. For this moment, for this time, for the millions of dollars that are spent, so they could say the president is impeached. That's a lofty history. Those are lofty goals that you now have authored more subpoenas than you created laws.
3 seconds remaining. The gentleman from New York has 1 minute remaining.
Thank you, Madam Speaker, and thank you for your
You're welcome.
Work. Look, the two facts that just came out right here, and again, we're going to hear in just a moment, but there are facts. Undoubtedly, the mics are not working on the other side, majority side. We've talked about the facts. There is not overwhelming evidence. We've discussed this over and over and over till we're blue in the face, but it doesn't matter because this is a political impeachment. This has nothing to do with the facts. We've shown that there was nothing done wrong.
Were debating how to set up a brand new government, they ran into a problem. What should happen if a president, in Benjamin Franklin's words, has rendered himself obnoxious? Most countries didn't have elected leaders or ways to get rid of them, so Franklin and the framers turned to a provision of British common law known as impeachment. Trial, conviction, punishment.
In Great Britain, impeachment could be brought against anybody, any citizen. And it also could result in any punishment, including death.
Michael Gerhardt is a constitutional law professor who literally wrote the book on impeachment.
And so they put impeachment into the Constitution and then set up a whole series of unique American features in it.
The Constitution lays out 3 offenses for which any federal official, including the president, can be impeached. The first 2, treason and bribery, are pretty straightforward. Treason means helping enemies of the United States, and bribery is taking money or gifts in exchange for a political favor.
And the last phrase, high crimes and misdemeanors, is hard to define. Obviously, it's not defined in the Constitution, but these were thought to be serious offenses against the Republic and serious breaches of trust.
For 3 U.S. presidents, Andrew Johnson, Richard Nixon, and Bill Clinton, the question of whether to impeach and remove them from office centered around whether their behavior fit into this 3rd category of high crimes and misdemeanors. The impeachment process has to start in the House of Representatives. Any member can introduce an impeachment resolution.
A resolution articles of impeachment of George Bush, President of the United States. Resolved, that President George W. Bush be impeached for high crimes and misdemeanors.
But plenty like this one go nowhere. That's because impeachment charges have to be approved by a majority of the House Judiciary Committee. Next, the full House of Representatives votes on whether to impeach. If a simple majority votes yes, the president is officially impeached. But that doesn't necessarily mean they lose the presidency. That decision happens in a Senate trial. The senators are basically the jury. They hear evidence from both sides, and if 67 of those senators vote to convict, the president is removed from office. This has never actually happened. A House majority voted to impeach Andrew Johnson for firing his Secretary of War. This was after months of conflict after Reconstruction following the Civil War. The only other president impeached by the House was Bill Clinton in 1998. But in both of those cases, not enough senators voted to actually remove the president from office. Johnson was only one vote short, but in Clinton's case, it wasn't even close.
The respondent, William Jefferson Clinton, President of the United States, is not guilty as charged in the second article of impeachment.
That's because votes in Clinton's impeachment in the House and trial in the Senate were split almost completely by party.
And part of the disagreement within the Senate had to do with the context in which Clinton's actions had taken place.
The whole thing started when Clinton was sued for sexual harassment by a woman named Paula Jones, who had worked for him when he was governor of Arkansas. In a deposition for that case, Jones's lawyers asked Clinton if he'd had a sexual relationship with a different woman, a White House intern named Monica Lewinsky. Clinton said he hadn't.
I did not have sexual relations with that woman, Miss Lewinsky.
But that wasn't true.
I had intimate contact with her that was inappropriate.
House will be in order.
Republicans in the House argued that Clinton should be impeached for lying under oath.
This is a public act, not a private act. What the defenders want to do is lower the standards by which we hold this president. You, sir, may resign your post.
Democrats disagreed that the offense was serious enough to be called a high crime. At one point, they walked out of the House chamber in protest.
There is one small segment on the far right who have lost all objectivity and are determined to impeach the president at all costs.
House Resolution 611.
Boy, that sounds fucking familiar, eh, Schumer?
That William Jefferson Clinton, President of the United States, is impeached for high crimes and misdemeanors.
But throughout this process, Clinton's popularity never really suffered.
In a sense, the American people are demanding that he be tossed out of office.
Not a single Democratic senator voted to remove Clinton from office.
Typically, you need to have members of more than one party.
That's one of the major differences between Clinton's case and President Richard Nixon's. Over the course of several months in 1973, members of Congress and the American people learned about Nixon's possible involvement in a break-in at the offices of the Democratic National Committee.
The Democratic National Committee is located in the Watergate office building.
The 5 men carried cameras and apparently had found an electronic bug.
The espionage operation on the president's behalf was called the Offensive Security Program.
The charge that the president knowingly participated in the Watergate cover-up.
That evidence only came out because Republicans, members of Nixon's own party, called for investigations into the president's behavior.
I welcome this kind of examination because people have got to know whether or not their president's a crook. Well, I'm not a crook.
What did the president know? And when did he know it?
In the House Judiciary Committee, Republicans joined with Democrats to approve articles of impeachment against Nixon.
Republicans began to kind of render a judgment against Nixon, which was his popularity plummeted.
But Nixon resigned before the full House could vote on impeachment.
I must put the interests of America first. I shall resign the presidency effective at noon tomorrow.
Republican leaders had told him there's no way he'd survive the vote, which helps explain why no president has ever been removed from office by impeachment. For that to happen, the president doesn't just have to commit some high crime or misdemeanor. He has to lose the support of his own party, in which case, history suggests he'll see himself out.
that this is not normal. It might look normal. You have the nominee, you have the family behind them, you have all the cameras on, but it wasn't normal. It wasn't normal because this nominee was handpicked by a president who, in just the last week, has gone after his attorney general, threatened to fire the deputy attorney general who's overseeing a major investigation, a national security investigation, handpicked by a president who's constantly undermining law enforcement, constantly undermining the FBI. And yet, this president picked a nominee who has the most expansive view of executive power that we've seen. A president, a view of executive power that, according to his writings and even the case law, says, in his own words, in an opinion, that a president should be able to declare laws unconstitutional. In his own views in legal writings, that a president should be able to be immune from investigation while sitting in office, that we shouldn't have a special counsel statute. So that's where we start. That's the core here as we look at the constitutional issues that we're facing. The second reason this isn't normal is that we did not get the information we needed to make a decision. I come from a state that believes in process. In my old job for 8 years, I headed up the Hennepin County Attorney's Office. We handled, by the way, 12,000 juvenile cases every single year. So I saw cases just like the one we heard about yesterday. But in our role, I would always tell people if we had to let a case go, if we had to make a deal that people didn't like, our role was to be ministers of justice. It was to convict the guilty, but also protecting the innocent. And I don't think we protected the innocent very well yesterday, and I certainly don't think that we're doing it today. There was a lot of chest beating that went on yesterday on the other side. And it was pretty effective, I guess, if the goal was to distract the American public for what they had heard in the morning, to distract and deflect from the moving, powerful testimony we heard. And I don't want to hear about respecting Dr. Ford when we are not giving her the respect of having an investigation of the case that she made to us yesterday. It was a while ago that this happened, and there's other claims out there as well. But it's been my experience, as Senator Whitehouse just articulated, that if you don't go back and look at things, and you don't look at corroborating evidence, and you don't talk to the witnesses, you're never going to know what happened. I have proposed and talked to some of my colleagues, and I know others have as well, as a finite period for an FBI investigation, maybe a week. George H.W. Bush ordered that in the Anita Hill case, a 3-day investigation. That happened. Whether people like that outcome or not, it happened. That is not even happening here. We are not even giving Dr. Ford the respect of having that investigation. And that is wrong. That is not being ministers of justice. This was a woman with no political background who made an attempt to call the front office of her congresswoman. That's what she did. She did this before the nominee was even picked. She did it when the nominee was on a short list because she was concerned. That's what she did. So don't argue that she is part of some massive political strategy. Those aren't the facts. And yes, it's messy. The justice system is messy. Things come in at the last minute. It happens all the time. It happens before a trial. It happens before a hearing. And the question is not if it's messy. Senator Flake himself said yesterday, this is not a good process, but it's all we've got. The question is, what do you do when it happens? When you're in a position of power? What do you do when it happens? You may not like how this came in at the last minute. I would have liked to known about it earlier too, but I didn't. The question is, what do you do when it happens? And when it happens, you don't just put it under the rug. For so many years, this is what happened to claims like this. They were just swept under the rug. What happened in the House, no matter how bad it was, didn't belong in the courthouse. And that hurt women and that hurt children for a long, long time. But the times are changing now. We have someone who made a credible claim. The chairman even thanked her for her bravery. Well, where is the bravery in this room? This rush, when in fact we could have a finite period of time to interview a finite period of witnesses. Someone who she alleges was in the very room where it happened. We are not able to even cross-examine them, ask them questions. We're not allowing the FBI to go in there and tell him to his face that you're going to get in criminal trouble if you don't answer these questions correctly. Instead, we get a letter behind the veil of a law firm. That's not the same thing. We have a polygraph expert. Yesterday, I put that polygraph exam on the record. People were bristling over there and said, well, we want to see the charts. Well, we would be happy to have the polygraph expert testify and explain how this was verified. And yes, as Judge Kavanaugh pointed out, this is not a test that is admissible in court. But guess what? We use it for job interviews. We use it for the FBI. We use it for the Defense Department. We use it for the CIA. And the nominee himself has even said that this is useful to use for those purposes in a case that he decided in 2016. Those are the kind of witnesses we could hear from if we had the opportunity, maybe 1 week, to do it. So I look at it this way. If we want to show Dr. Ford respect, we give her the respect of having her case heard and the evidence looked at. I look at it as, what are you hiding? What would it hurt? If Judge Kavanaugh is so sure that he has this corroborating evidence and what this calendar means and what these things mean, then what is he afraid of if we just spend 1 week looking at the evidence? What I have heard today just adds to this. When I heard this sanctimonious talk about some kind of a political strategy, well, I'll give you Exhibit A, Merrick Garland, who was delayed for nearly 10 months. You talk about a nominee getting off the floor when all we're asking for is 1 week for an investigation, and you kept Merrick Garland away from this committee for 10 months? That's not even a comparison. That was a strategy yesterday. And boy, was it a strategy. And I sure hope that some of the senators who have not yet made a decision, who are not on this committee, will look at the evidence and look at what happened and see it for the strategy that it was. I asked Dr. Ford yesterday about what she remembers from that night. And I also asked her what she couldn't forget. And here's what she said. The stairwell, the living room, the bedroom, the bed on the right side of the room, the bathroom in close proximity, the laughter, the uproarious laughter, the multiple attempts to escape, and the final ability to do so. We heard her talk about how she had a civic duty to bring this up. We heard her testify about how she had actually brought this up 6 years before to a counselor, about how her husband recalls her using the judge's name. In the rules of evidence, it says that statements made to a professional, to a medical professional, are considered to be credible. In cases, when you compare evidence, you look at people's, what their goals are. What would be their reasons to lie? And I look at, you have on one hand a judge who is a career-making moment to get on the United States Supreme Court. And by the way, no one is entitled to be on the United States Supreme Court. And then you have a woman who tried to keep this confidential, who came forward, sent a letter, tried to do what she could to keep her name out of the news, and finally, when the reporters showed up at her door, she came forward. I just see these as different. And when you look at the rules of evidence, when you look at credibility, the fact that she had mentioned this years before, means a lot. But you could have doubters. I understand that. But when we don't have an investigation and we don't have things in writing to be able to look at the facts, where are we? I have been on this committee for a number of years, and I have been briefed on FBI background checks. And a number of times, and my colleagues know this, nominees withdraw because of what is in those background checks. They pull their names out. The press never knows it, but it happens. Or sometimes we're presented with some information that's not public, and we have to make a decision. Well, does this drug use amount to something that should keep this person off the bench? Does looking at this website amount to keeping this person off the bench? These are things we've actually considered. That's the kind of information we get from those background checks. And I think it's a good thing, because not everyone needs to be dragged through the mud. Things are contained in a background check. Do we have order?
She's just grandstanding. That's Amy, fucking bitch bag.
Background checks are useful for us, and they're useful for the American people. I, for one, don't want to live in an evidence-free zone. We need this information. I would submit to my friends across the aisle that this is not a he said, she said. This is a he said, they said. There are a number of people out there who have talked about the fact, including the nominee's roommate, that he is belligerent when he gets drunk. Yes, that was a long time ago. Maybe he doesn't do that anymore. And I know people in high school drink a lot and in college, but when I asked him about this to try to get to the facts, I'm not an FBI agent, but all I was trying to do was try to figure out, well, maybe he has partially memory loss when he gets that drunk. Or maybe he blacks out. I don't know. I was trying to get that. What did I get in response? A question of if I black out. Did he apologize? He did. And I appreciated that. But the point is, if we could have the FBI, like we do with all background checks, interview these witnesses, we could get to the bottom of the facts. Judge Kavanaugh said on Fox News and yesterday that he wants a fair process. That's what he said he wants. And when I asked the judge why he wouldn't ask the president to have the FBI reopen the investigation yesterday, he didn't make that request. He didn't really answer that question. There are only a few people in America right now that can reopen that investigation. The one sitting across the room, because yes, Senator Grassley could have held off this vote until we had that investigation. Judge Kavanaugh could have easily said, Mr. President, for this to move forward, I want to at least clear my name, but mostly I want to have the American people know whether or not this is true or not. He could have done that. Why didn't he do it? Because they're afraid of what they'll find out. Yesterday, the American Bar Association, as Senator Durbin has just noted and read the letter, sent a letter urging the committee not to vote on Judge Kavanaugh's nomination until the FBI has conducted appropriate follow-up. The ABA said that it made that request because of its, quote, respect for the rule of law and due process under law. I'm just waiting until the staff is done talking.
Why? Nobody wants to listen to your fucking fat mouth anymore anyway. You're just grandstanding. You're tearing up some guy that you're going to find out in about a week that the bitch was full of shit.
The ABA said that it made the request because of its respect for the rule of law and due process under the law. I chose to get on this committee. I didn't get on it right away because I'd done this work for 8 years before I got on here. I got on here 2 years after I got to the Senate because I decided I wanted to continue that work, to uphold the respect for the rule of law and due process under the law. But that's not what I saw yesterday. So if this committee isn't going to respect the law, and if we go to the floor and the same thing happens again, I would remind my colleagues that the Constitution does not say we, the ruling party. The Constitution says we, the people. And if the people of this country want to have a check and balance in the Supreme Court, a check and balance on this administration, if they want to have a fair process, they're the only ones left to pitch in here. They're the only ones left to have a say. Because right now, the way this process is run, we're not running it like we the people. It's being run like we the ruling party. I vote no.
You were quite critical of the CFPB, stating that, I got to get the right page in front of me, but if I paraphrase, that it's a sad, sick joke. Do you still believe that CFPB is a sad, sick joke?
Yes, sir, I do. And I'll be happy to tell you why. It is, to me, sir, one of the most offensive concepts, I think, in a representative government, which is almost completely unaccountable government bureaucracy, government regulatory agency. One of the most frustrating experiences I've had since I've been in Congress is people walking into my office and asking me for help and having me look them in the eye and say, I'm sorry, there's no way under any circumstance that I can help you. And that's what I've been forced to do with the CFPB. Because they are off appropriations, because we don't budget for them, because they're run by essentially a one-person dictator who believes he can't even be fired by the president but for cause, we have created, perhaps inadvertently, the very worst kind of government entity.
This has actually worked. I mean, if you take a look at how to create an effective organization fighting for ordinary working Americans, I mean, this is it.
Senator, all I can tell you is I've had probably more complaints about the CFPB in my office from small local banks and credit unions, which I'm not from a big bank area, than every other government agency put together. So I respectfully disagree with you, sir.
Has it occurred to you that there's a certain irony here, that here the president is accused of and has acknowledged wanting to get information about your son Hunter and his dealings with Ukraine, and this process of impeachment has ensured that everyone knows about Hunter's dealings with Ukraine?
That's a good thing, and no one's found anything wrong with his dealings with Ukraine, except they say it sets a bad image.
Well, do you agree that it sets a bad image?
And my son said that.
Do you think it was wrong for him to take that position?
No.
Knowing that it was really because that company wanted access to you.
Well, that's not true. You're saying things you do not know what you're talking about. No one said that. Who said that?
Well, don't you think that it's just one of those things where people think, well, that seems kind of sleazy. Why would he have that job if not for who his father was?
Because he's a very bright guy.
I guess the question I'm kind of asking is, was it right?
His appearance.
Yeah.
Yeah. Well, he said he regretted having done it. Speaks for himself. It's a grown man.
You're going to predict a win tomorrow night? Impeachment has ensured that everyone knows about Hunter's dealings with Ukraine.
That's a good thing, and no one's found anything wrong with his dealings with Ukraine, except they say it sets a bad image.
Well, do you agree that it sets a bad image?
And my son said that.
Do you think it was wrong for him to take that position, knowing that it was really because that company wanted access to you?
Well, that's not true. You're saying things you do not know what you're talking about. No one...
just a vote on whether you like the president or not, whether you agree with the president or not, whether your politics are the same. This is a vote over whether the constitutional standard is met. And the Constitution says for impeachment that the only grounds for impeachment are treason, bribery, or other high crimes and misdemeanors. And what Professor Dershowitz walked through very effectively, and actually before him, what Ken Starr walked through very effectively, is that the constitutional threshold requires a grave, serious crime of the level of treason or bribery. House managers didn't even try to allege a crime, and they certainly didn't prove one, and that's why, as a matter of law, and by the way, we did this whole digression on quid pro quo and all the discussion about additional witnesses for whether there was a quid pro quo, whether there wasn't a quid pro quo. As a matter of law, it didn't matter. It was a side diversion. That was one of the things we clarified during the questioning period that I think was really critical to getting the 4 votes to end, to not have additional witnesses, is that we asked, actually Lindsey Graham and I together wrote the question asking, even if you assume, for sake of argument, that there was a quid pro quo, does that change the legal analysis? Is this a high crime or misdemeanor? And the president's lawyers answered exactly right, that even if there were a quid pro quo, you got disputed testimony on that, it doesn't matter, because the president has the authority to investigate corruption, and there was more than sufficient evidence of potential corruption with Burisma and the Bidens for the president to ask for an investigation on it.
Donald Trump couldn't find Ukraine on a map if you had the letter U and a picture of an actual physical crane next to it. He knows that this is, an administration defined by ignorance of the world.
You can put half of Trump's supporters into what I call the basket of deplorableness.
And so that's partly him playing to their base.
Anyone who supported this president is, at best, looking the other way on racism, at best.
The credulous boomer Rube demo that backs Donald Trump, that wants to think that Donald Trump's a smart one, and y'all elitists are them.
Trump always loves the low information guy.
You elitists with your geography and your maps.
Racism across the country, because that's his base.
Your math and your reading.
Yeah, you're reading, your geography.
Attempt by the House to attempt an accommodations process, even though the White House offered to engage in an accommodations process. There was no attempt by the House to use other mechanisms to resolve the differences with the executive branch. It was just straight to impeachment. Now, they've asserted today and on other occasions that the president's counsel, that I and my colleagues have made bad faith legal arguments that are just window dressing. Now, in an ordinary court of law, one doesn't accuse opposing counsel of making bad faith arguments lightly. And if you make that accusation, it has to be backed up with analysis. But there hasn't been analysis here. There's just been accusation. When the president asserts the immunity of his senior advisors, that's a principle that's been asserted by virtually every president since Nixon. And let me read you what Attorney General Janet Reno, during the Clinton administration, said about this exact immunity. She said that immediate advisors to the president are immune from being compelled to testify before Congress, and that, quote, the immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests, end quote. And she went on to say, quote, compelling one of the president's immediate advisors to testify on a matter of executive decision-making would raise serious constitutional problems no matter what the assertion of congressional need, end quote. Was that bad faith? Was Attorney General Reno asserting that principle in bad faith? And President Clinton? President Obama asserted the same principle for his senior political advisor. Was that bad faith? Of course not. These are principles defending the separation of powers that presidents have asserted for decades. President Trump was defending the institutional interests of the office of the presidency and asserting the same principles here. That is vital for the continued operation of the separation of powers. Now, House managers have also said that once the president asserted these defects in their subpoenas and resisted them, they had no time to do anything else. They had to just go straight to impeachment. They couldn't accommodate, they couldn't go through a contempt process, they couldn't litigate. But the idea that there is no time for dealing with that friction with the executive branch is really antithetical to the proper functioning of the separation of powers. It goes against part of the way the separation of powers is supposed to work. That interbranch friction is meant to take time to resolve. It's meant to slow things down and to be somewhat difficult to work through and to force the branches to work together to accommodate the interests of each branch, not just to jump to the conclusion that, well, we have no time for that. We have to assert absolute authority on one side of the equation. And this is something that Justice Brandeis pointed out in a famous dissent in Myers versus the United States, but has since been cited many times by the court majority. He said, quote, "The doctrine of the separation of powers was adopted by the Convention of 1787 not to promote efficiency," so he's saying not to make government move quickly, "but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among the departments, to save the people from autocracy." That is a vitally important principle, that the friction between the branches, even if it means taking longer, even if it means not jumping straight to impeachment, is part of the constitutional design. And it's required to force the branches to determine incrementally where their interests lie, so to resolve disputes incrementally, and not to jump straight to the ultimate nuclear weapon of the Constitution. We've also heard from the House managers that everything the president did here, asserting prerogatives of his office, asserting principles of immunity, must be wrong, must be rejected, because only the guilty will assert a privilege. Only the guilty won't allow evidence. That is definitely not a principle of American jurisprudence. It's antithetical to fundamental principles of our system of laws. As we pointed out in our trial memorandum in Border-Kircher versus Hayes and in other decisions, the Supreme Court has made clear that the very idea of punishing someone for asserting rights or privileges, or suggesting that asserting the right or privilege is evidence of guilt, is contrary to basic principles of due process. And it takes on an even more malignant tenor to it when that principle is asserted in the context of a dispute between the branches relating to the boundaries of their relative powers. Because what the House is essentially asserting in this case is that any assertion of the prerogatives of the office of the president, any attempt to maintain the principles of separation of powers, of executive confidentiality that have been asserted by past presidents, can be treated by the House as evidence of guilt. And here their entire second article of impeachment is structured on the assumption that the House can treat the assertion of principles grounded in the separation of powers as an impeachable offense. I mean, boiled down to its essence, it is an assertion that defending the separation of powers, if the president does it in a way that they don't like, in a time that they don't like, can be treated as an impeachable offense. And that's an incredibly dangerous assertion, because if it were accepted, it would fundamentally alter the balance between the different branches of our government. It would suggest, and Professor Turley explained this, Professor Dershowitz explained it here, that if Congress makes a demand on the executive and the executive resists, based on separation of powers principles that past presidents have asserted, Congress can nonetheless say, we've decided to proceed by impeachment. We have the sole power, and this is the principle they assert in the House Judiciary Committee report. We have the sole power of impeachment. That means we are the sole judge of our own actions. There's no need for accommodation. There's no need for the courts. We will determine that any resistance you provide is itself impeachable. That would fundamentally transform our government by essentially giving the House the same sort of power as a parliamentary system. to use impeachment as in effect a vote of no confidence against a prime minister, not the way the framers set up our three-branch system of government with a powerful executive who would be independent from the legislature. That's why Professor Turley explained that the second article of impeachment here would be an abuse of power by Congress. It would make the executive dependent on Congress in a manner antithetical to the system that the framers envisioned. So why is it that there are all of these defects in the House manager's case for impeachment? Why are they asserting principles like only the guilty would assert privileges? That's not part of our system of law. Why are they asserting that if the executive resists, the House has the sole power to determine the boundaries of its own power in relation to the executive? Also not something that is in our system of jurisprudence. I think it's because, and why the lack of due process in the proceedings below? I think, as we've explained, it's because this was a purely partisan impeachment from the start. It was purely partisan and purely political. And that's something that the framers foresaw. And I'll point to one passage from Federalist number 65. A number of different passages from that have been cited over the course of the past week. But I don't think this one has. It's just after Hamilton points out, he warns that an impeachment in the House could be the result of persecution of an intemperate or designing majority in the House of Representatives. And then he goes on. Though this latter supposition may seem harsh and might not likely often to be verified, yet it ought not to be forgotten that the demon of faction will, at certain seasons, extend his scepter over all numerous bodies of men. Now that's very 18th century language. We don't talk about demons extending their scepter over men, but it's prescient nonetheless. We might not be comfortable with the terms, but it's accurate for what can happen. And that is what's happened in this impeachment. This was a purely partisan political process. It was opposed bipartisanly in the House. It was done by a process that was not designed to persuade anyone or to get to the truth or to provide process and abide by past precedents. It was done to get it finished by Christmas on a political timetable. And it's not something that this chamber should condone. That in itself provides a sufficient and substantial reason for rejecting the articles of impeachment. Members of the Senate, it's been an honor to be able to address you over the past week and a half or 2 weeks. And I thank you for your attention, and I yield to Mr. Secretary.